For physical mentioning, Mr. Abhijit Pal.
Yes. My lords, this is that matter where I mentioned 1 week back. Justice, the matter was listed on Monday. He sent it back. So maybe listed tomorrow. It's urgency.
All right, tomorrow.
Grateful, man.
Supplementary list item to be taken up at 10:30 am. Item number 12. WPC 6610 of 2006.
Lordship, may I just ask for one pass away, Lordship? Mr. Mishra is on his legs.
All right.
Okay.
This is supplementary.
In this case, I may be permitted to inform one thing to your lordship. The DG of prisons now changed. Today, the new incumbent going to be Mr. Manoj Chabra.
Oh.
So, but we have filed an affidavit today, exhaustive affidavit with documents. But the new DG has to be equipped with all these past events and all. If your lordship will hear it today or
Let Mr. Gautam Mishra
yes,
be
yes. I am giving a copy to amicus curiae today's affidavit.
Lordship, we already received a copy. We'll just apprise your Lordship about the compliance with the directions of your Lordship. And then new DG can, of course.
Because I think work is happening.
Lordship,
From what I
Yes,
could see.
yes, my lord.
Lordship.
Yes, my lord.
Substantial
Your
works have
lordship can
taken
see the
place here.
annexures. Many developments are there in the meantime. Pursuant to your all, the amicus curiae also. Amicus curiae will also acknowledge that there are a lot of developments in the meanwhile,
Right.
and all the related documents we have annexed in the affidavit.
Okay.
Lordship. We'll be showing those photographs and the videos. Lordship.
Right.
And
Just
there
one
may be
pass.
some shortfall.
No, not
that will be
shortfalls. Even
rectified
complaints
in
have been
due
made
course.
to a large extent.
No, we'll
more
see
work-
what has come so far and then we'll
Okay.
again hear it elaborately.
Yes,
Maybe not elaborately today, but we'll hear it on some other day.
Yes.
Lordship. Great.
Supplementary list fresh admission item number 1.
May I please, your lordship? The petitioners are the villagers of two different villages. In spite of the direction of the additional Tahsildar to evict the OP number 5 from the government land, the authority have not taken any step to evict the opposite party number 5 from the government land. Your lordship may kindly see annexure 2, annexure 1 is the record of right, which shows that the land was recorded in the name of state government. The OP number
So
5.
we'll ask the representation to be considered.
Annexure 3, Tahsildar, Nimapada.
Okay.
2nd February 2020.
Annexure 3. Be examined by the Tahsildar Nimapada. And after issuing notice to the petitioners as well as opposite party number 5, and after giving them a hearing, a reasoned order should be passed thereon not later than 4 July 2022 and be communicated to the parties not later than 11 July 2022. The court clarifies it has not expressed any view in the matter. The petition is disposed of.
Within a stipulated period.
Right, that's all. Yes,
Item 12.
You have given a pen drive, my lord.
I know. I saw a bit of it. I think we can play a bit of it.
My lords.
Pen drive. No. Which jail is this? Just go back. Go back. Which jail is this? Aska. Keep moving.
We had selected some photos for the court regarding Circle Jail, Puri.
This is Katak, I think.
Yes, Circle Jail, Chodwar. There also this, if my lord would see,
Yeah, it's pretty
the
bad.
improvements are not there.
Yeah.
And these are all circle jails. So these are the prominent ones where they have to be more vigilant.
This has come from the DLSS.
This has come from the DLSs. All the DLSs have visited pursuant to my lord's order. And of course, there have been improvements in many jails, but the ones which have been pointed out there, the situation is very grim.
Which jail?
I'll just list that out.
Aska, Badamba, these are, okay.
I think all these vegetables have now emerged. We can see they're now trying to paint it, and
Yes,
I think that civil work part is going on now.
my lord.
What was that which you just saw? Before that. Circle Jail, Puri, and Badamba, Kathak. And this is Chaudhar. Chaudhar itself is so bad.
Yes, ma'am.
Bathroom is,
No, even this, sir. Just see this. No drains, nothing. Chaudhar is really bad. Chaudhar is supposed to be a central jail, no?
that is a central jail.
Where is this? Let's go back. Uchinda.
Yes.
All right. Malkangiri. Oh, my goodness. Atgar.
I think this is due to overcrowding at Chaudhar jail.
Where is this?
They're all subfolders.
Atgar.
Yes, ma'am.
Oh. Actually, the maintenance is very poor.
Athagar,
It's Atgar.
yes, ma'am.
My goodness. How come the entire hall is empty? There are no chairs, tables, nothing. Huh? It's supposed to be dining hall, nothing is there. No, just go back. Just show us the other one. No, इसी में निम्बूपाड़ा में no ward. Okay. Nimapada is slightly better. The bathrooms are bad. Okay. I think the toilets are the worst, sir. Somehow it's almost like they don't deserve.
Which jail your lordship is referring?
Sub jail where?
Visam Katta.
Bisham Katta. Okay. Those are all those NOVs, non-official visitors.
Yes, ma'am.
So, all right. You
Now-
got this note.
Yes, sir.
There's one
Just now I received.
serious
The
issue.
new DG is present with us, or
No. Additional IG is present, new DG is not present.
all right. Sir, the additional IG, what is his name?
Sitaram, Mr. Sitaram.
Mr. Sitaram? You can unmute, sir.
Unmute kar diyantu.
Ha. Mr. Sitaram, you saw the photographs which we just saw?
Not visual, sir.
No, this is not being
Oh,
shown.
it
This
is
is
not
not
shown.
shown to the.
Okay. We'll organize to send you the photographs we just saw. we'll give it to Mr. Manti, our your additional government advocate.
No, they have been all given to them. I think
Everything
they
is
have all
with us.
received.
Everything is with
I see.
us. We will send it to him.
All right, all right, all right.
There's one more serious issue, my lord.
Sir, Chaudhar needs some urgent attention, sir. Circle Jail, Chaudhar, the situation is very bad.
Sir,
And Chaudhar is just not even 15 minutes from here. We cannot afford to have a circle jail in Cuttack, which is so bad, sir.
sir, allotment has been given. We have requested the executive engineer to release the funds and go up with the work, sir.
Yes, yes. We need to see some real improvement, sir. Please tell whoever is in charge.
Sir.
Uh,
In this convenience note, I have given one disturbing feature. My lords may see at page 9 of that note. This came out from one of the reports. Even in the earlier reports, it's there regarding the sub jail Atta Malik, my lords.
oh, they were tortured in the sub jail.
Just because they complained.
Oh,
And there are other allegations that the convicts are the ones who are controlling that entire jail.
in Atta Malik.
Yes, ma'am. There are also unconfirmed allegations against the
I'll try
warden.
to get instructions on this particular issue because it's a very sensitive issue.
So what I was submitting, my lords, is that the learned sessions judge, Angul, he may inquire into the sub jail Atmalik and the district jail Angul, because
Right.
these are the places where they have been interchanged.
Right.
Because there are some unconfirmed allegations against the warder also.
Okay. Okay.
This I have incorporated in the
Right.
soft versions also I have shared of the convenience note.
Water supply. District Jail Puri has poor water supply. It's unbelievable, sir.
That is there as per the report.
In fact, like Chaudhar, if my lord would see the pictures of Puri, Puri is also one of the prominent jails where the condition is really bad. Those photos we had selected for.
Right. No, we've seen it. We saw them. So you can again give us a soft copy of this. We'll put it in the order.
Already shared,
All right.
already given the pen.
All right.
So far as the superintendent of jail Puri, we have already initiated page 3 of my affidavit may kindly be seen. Page 3. A, para A,
Right.
capital
Right. Right.
A. And B also.
Right. This is very important. Very important. The district jail Puri figures in everything, sir. Ward cleanliness, cooking area, food and nutrition.
कौन डालत में खींचे अनेक्सर कितने
Sir, on decongestion, what is the latest? Sir? Because this seems to be a recurrent problem. Where are we on this decongestion?
Decongestion of what?
Prisons, the decongestion of prisons, sir. Many of them are still overcrowded. Last time, if you remember 2 hearings ago, we were given a plan for decongestion, about how they're planning to shift prisoners and hire new premises, build additional wards. What is the progress in all of that, sir, that we are not clear? I think the new DG asked him to completely take a review of this whole thing.
Yes, ma'am. Yes, ma'am. That.
What?
He will join by tomorrow or day after tomorrow.
Can it be on Saturday, 21st?
Ah. All right.
21st would be 23rd. Actually, yesterday I just booked.
No, it's okay. It's okay. It's fair enough. What about Mr. Manti? 21st, Saturday?
I will be there.
All right. You'll be there.
That is the last date of before vacation. Anyway, I will be there. Only this case will be listed.
Only this case will be listed.
Yes.
We just passed some orders because that on that overcrowding, I think we need to pay.
Overcrowding, actually, we are moving around in circles. In those meetings also, they are just plugging one place, then the other one comes up. Overcrowding is something which the state has to
I'm
seriously look at.
keeping it 21st because we need a concrete plan. This new
My lord
DG.
may give a direction in the order what are to be complied by us, and your lordship may direct the new DG to appear in person on that.
Correct.
So, lot of effort is going into it, but the results on the ground level are not there.
Correct.
And if my lords would see the 2 jails in page 3 of my convenience note, particularly Baliguda and Nayagarh, the DLSA reports are really bad. They say that no action has been taken even in spite of the court orders. Page 3 regarding the restrooms and toilets.
It's not there, is it? Sorry, page 3.
Page 3 of that convenience note given today. And those reports are also there regarding sub-jail Baliguda and Nayagarh. Particularly, there is no action.
No
action taken even though the court has directed. So something my lords may say regarding these 2 sub-jails. The DLSs have been actually going to each and every jail, they are reporting.
Right. Pursuant to the order passed by this court on 20th April 2022, reports have been received from several of the District Legal Services Authorities, DLSAs. The court expresses its appreciation of the promptness with which the DLSAs have swung into action, visited all the jails, sub-jails in Orissa, and submitted their photographs, videographs, along with their reports. Full stop. Paragraph. These reports have been analyzed by the learned amicus curiae, Mr. Gautam Mishra, senior advocate, and a convenience note has been placed before the court. Full stop. While there is significant progress in improving the facilities, the hygiene, and the living conditions of the jails and the living conditions of prisoners, and some of this is evident in the photographs sent to the court, video clips sent to the court. Much more still requires to be done. Paragraph. The learned amicus curiae highlighted how, despite the orders of the court, no steps whatsoever have been taken to improve the conditions in the sub-jail Baliguda and the sub-jail Nayagarh, Full stop. A specific direction is issued to the concerned prison officials to immediately take steps to rectify the defects pointed out in the video clips, photographs, and the reports. The prison officials, the non-official visitors will immediately undertake a visit along with the district judge in both these places to ensure that the living conditions, the hygiene, the sanitation, quality of food, and other issues pointed out are attended to immediately. Paragraph. From the note, convenience note, it transpires that the condition in the district jail in Puri is still poor. Full stop. It figures on the issue of insufficient water supply, repair and improvements to the toilets, improvement to the wards, kitchen and drinking water facilities, food and nutrition in terms of quantity of food. Full stop. Although the affidavit filed today on behalf of the state by the Deputy Inspector General of Prisons, Shri Shubhakanta Mishra, states that disciplinary action has been taken against the jail officials in Puri and Khandapada. An explanation has been sought from superintendent of several other jails, including the jails at Soru, Jashpur, Jharsuguda, G. Udayagiri, Phulbani, Baliguda, Puri, Baleshwar, and Nilgiri. It appears that constant efforts have to be made to improve the conditions in many of these jails. Full stop. One disturbing aspect that has been brought to the attention of the court involves the sub-jail at Attamalik. Full stop. The report of the DLSA, Secretary DLSA Anugul, has stated how inmates recently transferred from sub-jail at Attamalik to the Anugul district jail informed the Secretary DLSA how brutally they were tortured at the sub-jail at Attamalik, which according to them is under the control of convicts instead of jail officials. Full stop. The court directs the district judge Anugul to immediately visit both the district jail at Anugul as well as the sub-jail at Attamalik, conduct an inquiry into the above complaint, and submit a report to this court before the next date. Full stop. The paragraph, the convenience note, has set out the sub-jails that still have insufficient water supply. The sub-jails at Malkangiri and Digapahandi, apart from the district jail at Puri, have insufficient water supply. Full stop. The toilets and restrooms, the special jail Rourkela, have not undergone any improvements. Full stop. The photographs of the model convict prison Attagad show that the toilets and restrooms there still require improvement, as do those at the sub-jail Palada, the sub-jail Malkangiri, the district jail Anugul, the sub-jail Talcher, the sub-jail at Narsinghpur, Badampa, R. Udaykarli, Parlekhamundi, Jharsuguda, Kujanga, and Ranpur. Stop. The court on viewing the photographs of the Circle Jail Chaudhar, notices that the toilets, restrooms, the drains are, to say the least, in a pathetic condition, as are the conditions in the wards. Full stop. Being the Circle Jail and located so close to Cuttack, there can be no excuse for the poor condition in which the Circle Jail is. Full stop. The court is informed that a new Director General has taken over. Mr.
Manoj
Chabra has recently taken over as Director General Prisons.
No, my lord, going to take over tomorrow or day after.
All right, will be
Already.
soon taking over as Director General Prisons. The court requests Mr. Chabra to undertake a personal visit to the Circle Jail at Chaudhar as one of the first tasks, and ensure that on a war footing, the conditions in the Circle Jail are considerably improved. Full stop. He may also look through the videos and video clips and photographs sent by the secretaries of the DLSAs to this court, copies of which have been provided to Mr. Mohanty, Additional Government Advocate. Full stop. He will notice that the wards in the sub-jails at Jagat Singhpur, Talcher, Palada, Jharsuguda, Kuchinda, Kujanga, Nayagad, and Khandapada require improvement. Full stop. The court requests him to also undertake a personal visit both to the district jail at Puri and the district jail at Anugun, since the reports point out to the poor condition of the drinking water facilities, the cooking area, and the food and nutrition in these jails. Full stop. He may go through the convenience note submitted by the learned amicus curiae, which points out that as many as 16 sub-jails in Orissa need considerable improvement in the medical facilities available. Full stop. The deficiencies either due to the absence of a full-time medical officer within the jail premises or insufficiency of hospital beds in proportion to the prison population. Full stop. The DG will have to take personal efforts to ensure the filling up of all the vacant posts.
My lord, in this regard, I would like to draw your lordship's attention to annexure today's affidavit at page 14. We have already decided to create 18 posts of regular medical officers in different jails.
All right.
Page 14, annexure E by 7.
Right. Mr. Mohanty has drawn attention to the court to the Home Department's letter dated 29th March 2022, creating posts of 18 regular medical officers in different jails. We'll stop. The next effort must be to fill up all these posts at the very earliest. Full stop. Likewise, mental health, professional care and facilities are not available in the district jail Anugun, sub-jail Baliguda and the sub-jail G. Udayagiri. Full stop. The visits of psychiatrists and counselors to the sub-jail at R. Udayagiri are stated to be very irregular. Full stop. The sub-jails at Dasapalla, Ranpur and Khandapada have to depend on outside hospitals or healthcare centers for mental health care support.
My lord, in this connection, page 30, annexure H by 1 may kindly be seen. Page 30. 30. Annexure H by 1. We have instructed the chief medical officers of all the 3 districts to depute mental health doctors.
It appears that in this regard, instructions have been issued on 4th May 2022 to the chief district medical officer at Baleshwar, Khandabal and Kentrapada for taking appropriate action. But this doesn't still cover our Udayagiri and also Dasfala. That's not covered by this. Anyway. Paragraph. Since the intervention by the court is ensuring improvements to the facilities, it is important to keep the monitoring of the directions of the court on short-term basis. Full stop. For this purpose, the court proposes to hear this petition at a special hearing at 10:30 a.m. on Saturday, 21st May.
And another thing I may be permitted to
The
place.
new DG is requested to remain present for the hearing in virtual mode.
Another thing I might, annexure K/1, page 33. We have already formulated the implementation committee as per the direction of the honorable. That may kindly.
Mr. Monty has drawn attention to the fact that by Circular 7 of 2022, issued by the Directorate of Prisons and Correctional Services, Orissa, on 20th April 2022, an implementation committee
Has already been constituted.
has been constituted. Full stop. The court notes that today's hearing, Mr.
Sitaram Patel,
Sitaram
chairman
Patel,
of the committee.
the additional IG of Prisons and the chairman of the said committee
Chairman of the set.
was present in virtual mode.
There's one report by the member secretary regarding that compliance of the PR bond direction. So he has given a letter. In fact, he can find out, he's there present in virtual mode. He can also find out that in the meanwhile, what are the numbers?
No, all three UTPs were,
Out of
except three others have been released.
Yes, yes. But that was the previous year's statistics.
Okay.
In the meanwhile, I think some new numbers must have come up.
All right. Mr. Monty,
Yes, ma'am.
you'll keep track of this UTPs who can't furnish bail bonds, correct? All right. You say on the issue of under trial prisoners who were unable to be released despite being granted bail, the Secretary OSLSA, Shri Bishwajit Monty, has reported that of the 381 UTPs in this category, all barring three have been released on bail. Full stop. The three remaining have been charged for sessions tribal offences. Full stop. Mr. Monty is requested to continue monitoring the instances of UTPs who may not be able to obtain release despite grant of bail on account of their inability to furnish the bail bond and take effective steps in that regard.
We are great.
Obliged.
All right.
Supplementary list item number 2.
Item 2, your lordship, is regarding the demolition of the prawn cultivation in Rajnagar district. Lordship, my senior is on his way. He is actually out
All
of
right.
town.
Pass over. All right.
Your lordship may kindly keep it after lunch.
No, we can't promise all that, please. Yes.
Which one?
Supplementary list item number 3.
The memo is taken on report. IA. The IA for withdrawal petition is allowed for the reasons stated there. The PL is disposed of.
Supplementary list item number 4.
This is that PIL pertaining to the release of vehicles from the Thane.
Correct.
Lord, on last date, your lordship has requested the London member secretary Usla to present the facts regarding the number of vehicles that are actually released during the after passing of this last order.
Yes, Mr. Monty.
Yes, my lord.
Yes.
Sir, I have supplied the compiled data.
I have compiled the data received from different PLSs.
Where is that?
This I have submitted.
Correct. Yes.
Number of vehicles released as per the SOP till date is 217. 217.
Right.
And the actual pendency as on 30th April is 1841. It doesn't match with the annexure A by 3.
All right. So the maximum vehicles still pending are in Cuttack, Baleshwar, Khurda,
Yes, sir.
Mayurbhanj. And
Yes.
Sundargarh seems to have a very heavy number, 306.
56.
Any reason why Sundargarh, nothing has happened and only now SOP, no vehicle was released in Sundargarh?
As per the SOP, no vehicle has been released.
No. Why is that? When there are so many vehicles left.
The modified SOP has been communicated to Sundargarh district,
All right.
and I'm told that he will be following that modified SOP.
All right. You say the Secretary, Orissa State Legal Services Authority, has presented the statistics regarding release of vehicles pursuant to the directions issued by this court in the present case. Till date, 217 vehicles have been released. 459 vehicles, seized vehicles have been disposed of. So only one unclaimed vehicle has been able to be disposed of. So the total pendency of applications for release of vehicles as on 30th April 2022 is 1841. Paragraph, the modified standard operating procedure bracket SOP has already been circulated to all the district judges. It is expected that the number of vehicles released and unclaimed vehicles disposed of will improve considerably by the next date of hearing. We'll stop. List for further monitoring we'll have it in the first week of July, Mr. Monty.
Lord, I just want to point out one thing, Lord.
Yes.
Lord, your Lords may kindly see our affidavit dated 11th of December 2021, Lord. Page 5. So we have also given a chart, Lord. In fact, all the SPs have the affidavit was filed by the Lord, the Additional Superintendent of Police CID Crime Branch, and he has stated that there are total 19,149 vehicles are right now, Lord, seized.
So you'll have to see, because these are number of applications pending for release of vehicle. You have to see whether this matches with what you're saying.
Right.
That's a December figure.
Yes, ma'am.
We're now in May.
Yes, ma'am.
So you can
I'll have it.
Full stop. Likewise, the police department will also place before the court statistics regarding the number of vehicles, which according to them, remain to be disposed of.
Yes.
6th July. We'll have it on 6th July, sir.
Yes.
When did we keep the NDPS matter? Any idea? When was the NDPS?
25th June.
NDPS.
That is on 31st May.
That is 31st May?
31st May, that will come up 31st May.
May? Can't be.
Yes. No date has been fixed. Last,
No,
all
but
the pending requests be attended to immediately and the reports be sent not later than 31st May.
no, but Mr. fixed a date.
No date has been fixed.
What is the repetition number, sir?
Petition number is 32580 by 2021.
See the 325.
Last dated 25th April 2022. 32580.
Posted to 18th of July.
18th of July, no? Ah. 18 July, sir. 18 July. All right. We'll fix it on the same day that 18 July.
Yes, ma'am.
All right. Thank you.
Supplementary list item number 5.
This is a second round litigation before your lordship. The first round litigation was in the form of a PIA. And second, the main, only the very silly point is here, but taking a long time to settle the matter. One of the case is that one Nidhipur village school merged, the nearest school merged which is nearby upper primary school. The primary school merged with upper primary school, and the decision taken in the year 2011 by the government. We have no objection on that. But our primary school situated at Nidhipur village in the year 1948, naturally in the process merged with the nearby village named Ghantikal upper primary school. That upper primary school established in the year 2003, much after, about more than 50 years after the school was established. So because of the old school, only we want that our name should be there. But some reason, some practice, they completely wiped away my village name from the school. That is the thing.
So these are not matters for PIL, sir.
Yes.
What should be the name of the school? Can't be a PIL matter, please.
Milord, similar such issue, Milord, the notification of the government was challenged, and your lordship, the honorable single judge has quashed the notification, and your lordship in WA number 417 of 2021, Milord, admitted the matter is in session before this honorable court. So let it be tagged to that, Milord. The similar such issue has been stayed by your lordship has stayed.
This is just about naming the school, sir. This is not about.
Yes, sir.
We are not inclined to interfere in these kind of matters.
No, my lord, my case is something different. This is a second round litigation. The first round litigation was PIL number in the year of 2016. My lord, 6007 of 2016. My lord, it was disposed of by Honorable Chief Justice at that point on 5/8/2019. Specifically, very silly point, my lord. Because of our village name deleted, we made complaint before the Director of Elementary Education Higher Authority. He directed his subordinate staff, the government officer, Deputy Inspector of School, to make an inquiry on the spot and gave a report. My lord, accordingly, he gave the report as per that. That is also in annexure, my lord. And his report says, my lord, our demand is quite genuine. And he talked to both the villagers. Both the villagers said no problem. It is not a liability to neither any government or any public. Only our village name will be added. And it will be permanent. The government officer reported it will be permanent. If the name will be merged, then it will be a permanent solution and no problem in any future. And accordingly, my lord, the report submitted. Honorable Chief Justice in the year 2019 specifically directed that basing on that, keeping view on that inquiry report by the government officer, Deputy Inspector Schools, my case may be considered. But they, again, in the year 2011, the one stand of the government was that everything is ready, but the school committee is not giving resolution, behaving like an helpless attitude before a school managing committee. This complaint was in the 2011. This complaint in the counter in the PIL by 2016. So the case also when disposed of, Honorable Chief Justice directed you dispose of the case with small matter as per the inquiry report. My lord, when they did not slept over the matter, then we constrained to file the contempt petition. And contempt also, your lordship disposed of. Then this petition filed before as a school member, the main point, the school committee is not giving any resolution in that regard. that a school committee member has filed this writ application. Then writ application converted to PIL. So now the petitioner himself, a member of the school managing committee. So school managing committee is not giving the resolution. This ground is taken by since 2011 to 2022. So how far is the government should behave an helpless attitude before a school managing committee? Government is the ultimate owner of the land. If it decides something ingenuine occurred, and then even that village 50 years 1948 school name only Nidhipur marked, as per my plan, nothing has happened. No loss to anybody, neither to their village, not to my village, not anything else. But totally wiping out my village name, something giving badly hot sentiment and the reputation of village village people.
We're not inclined, sir. These are not matters for PIL. How a school should be named, whether some village's name should be in the school, not be there. This is not matters for PIL. Sir.
But these has diverted PIL as per your lordship. I have filed a writ application, not PIL. But as per Honorable Chief Justice order, that is, this should be treated as PIL. And I filed a second copy. Now this matter come before your lordship. I have not filed a PIL. I filed this application.
Even if you did not file it as a PIL, file it only as a writ petition, still this is not a matter for the court, sir.
Then where I'll go as a citizen of the village?
There are so many problems in life, sir. Every problem in life don't come to the court.
No, if
something has to be done at different level with the government. You have to pursue. You have to do.
I agree, my lord.
Yes.
But when government
for every problem, court is not the solution.
No, yes, I agree. Yes. But what a government can the school
and this question where I should go, you are asking free legal advice.
Okay, my lord.
So here we are not here to give free legal advice.
As an intellectual and the responsible person of the society, should he not have that responsibility if a mistake committed or a matter can bring to a final end to it? Should we linger it from 11 to 2020? Then, my lord, we again will go for another some years. The matter is that our village name to be entered in the school. This is not a big problem, nothing, nowhere lost to anybody. Nobody has any complaint for that. Only for a tactical thing, and we will suffer.
On the issue whether the name of a particular school should contain the name of a village or not is not an issue that the court is inclined to entertain in a public interest litigation. Leaving it open to the petitioner to explore other avenues as may be available to the petitioner in accordance with law. The petition is disposed of.
Supplementary list item number 6.
One second. Previous it was Honorable High Court entertained as a PIL from 16 to 2019. Now my lord not entertained. Something confusing, my lord. Not Honorable High Court does not take stand in equal in all cases. Another PIL entertained in this matter. Now my lord it is not PIL, not. We have no choice. We have to bow down.
All right.
But two stands my lord taken by this honorable court.
All right, sir. All right.
My lord, Chief Justice as for the inquiry.
See, this itself shows you how ineffective orders of the court are likely to be if they interfere in these matters. See, one thing is passing orders. The other is passing orders that can be implemented. Correct?
Yes, ma'am. But on the cause also, the dispute cause. Dispute not
the efficacy of the judicial system will come to serious question if we keep passing orders which cannot be implemented and which will not be implemented. So we must be aware of that.
Yes, but when injustice occurred,
sir, injustice, sir, from the time of human civilization, there have been instances of injustice.
Yes, ma'am.
For every injustice, there is no question of coming in a PIL to the court.
Not PIL.
For different kinds of injustice, you have different evidence.
That is the reason writ application I had filed, not PIL.
Right.
My lord directed for PIL, not I had filed writ application of the school member committee. The only stand taken by the government, we are helpless people as school committee, not giving resolution. But that means that this PIL filed, this writ application filed by a school member.
All right.
School committee member.
All right.
My lord, direction authority, may I pray again? Maybe direction to the higher authority to consider my genuineness and gravity of.
We have left it open to you, sir. You can pursue all that. Right.
High Court actually 2022 अपने कथा कोई 6 वर्ष over के तो 2016 I came to the PIL entertain continue for 19 now in the 2000 again told you go and take your own course and Sita I will go to court submit or will try to practice also. As a concurrent.
All right.
We are undone.
Right. All right. All right, sir.
But we don't do. I think I did not get proper justice.
Supplementary list item number 6.
Pass over. Pass over.
Supplementary list item number 7.
Item number 7, my lord, I am in virtual mode, my lord. This is a public investigation seeking for a direction to complete the Kalyan Mandap, work of the Kalyan Mandap, which was supposed to have been completed on or before 38/2021.
There are numerous defects in your matter. You please kindly remove, kindly cure all the defects.
Defects, my lord, I have to verify.
Yes,
All right, my
kindly do that, sir. Kindly do that. The defects be cured within 1 week, list thereafter. All right, sir. All right.
Supplementary list item number 8. Item number 8.
Please, Your Lordship, this is matter relating to Sikhya Sahayak.
Again, sir, lots of defects.
My Lord, according to the roster, my Lord, this matter should be placed before Honorable Justice M.S. Sahu, sir.
We don't know it's a PIL matter.
No, it's not a PIL matter, my Lord.
That's what you have filed it as. You have to look at the defects, sir.
My Lord, as
The
on
defects be cured, list after that, thereafter.
Supplementary list item number 9.
The covered, may it please, Lordship. The covered matter, that inadequate time given by the
who's for the other side?
Mr.
Chimaka. Challenge assessment.
My lords, similar matters, my lords have interfered.
Challenge assessment.
And secondly, my lords, Mr. Chimaka is not aware, my lords, the draft assessment order is to be sent under clause 21 of the faceless assessment scheme. 144B, clause 21 says draft assessment order is to be sent. Annexure 10 at page 78, lords will find the so-called notice was given superseding 2 other earlier so-called notices. But the draft assessment order was not sent. And that is a must, mandatory, that you have to send the draft assessment order to the assessee where there is a variation is to be proposed.
Notice is not gone in this.
No, my lord. Notice has
All
not.
right. Notice, Mr. Chimanka accepts notice. Reply be filed within 4 weeks, rejoined for the next date. Till next date, no coercive steps shall be taken against the petitioner.
An extra copy be kindly given.
Yes. List on 29th August.
Obligement.
Supplementary list item number 10.
Wait, please, Your Lordship. Lord, may I draw Your Lordship's attention to order dated 14/3/22, my Lord, order number 7.
Yes. Yes.
Lord, paragraph 3 of the said order, my Lord.
Correct. Correct.
Pursuant to Your Lordship's directions, my Lord, and as I had stated in the court, my Lord, I have brought the demand drafts.
Oh, I see.
My Lord.
All right.
I have filed a memo today with the calculations, my Lord.
Okay.
My Lord, one of the petitioners said to make the demand draft in favor of the HUF, but Your Lordship's direction was in favor of the petitioners, my Lord. We have made the demand draft, my Lord. Your Lordship will see today's memo at page 1, my Lord. Page 1, paragraph number 4.0, my Lord, at page 1 of today's memo.
Right.
That's the calculation, my Lord, from November 2013 till April 22 at the rate of 20,000 rupees per month for 102 months is 20,40,000, my Lord. On the next page, the amount is divided between both the petitioners, my Lord, as has been hitherto paid, minus the TDS amount, my Lord.
Right.
Each demand draft for 9,18,000 rupees, my Lord. And the copies of the demand draft is at page 4 of this memo, my Lord.
Yes, my Lord.
I have
Your
got the
Lordship directed accordingly, my Lord, for negotiation. Your Lordship that ask the order next time, next date, earlier date, that in the event of satisfying the order of the Honorable Court, fulfilling the order of the court, Your Lordship may be willing to direct for negotiation.
Negotiation.
So
All right, I'm
negotiation,
obliged.
Your Lordship may give.
All right.
That's a time-bound negotiation, my Lord.
Yes, yes, yes.
Yes, my Lord.
All right. You say pursuant to the order passed by this court on 14 March 2022, HPCL has filed a memo pointing out that they have prepared two demand drafts, in one each in favor of the two petitioners for equal amounts of rupees 10,20,000 minus TDS under section 194I of the Income Tax Act 1961, thereby working out to rupees 918,000. The two demand drafts have been handed over to counsel for the petitioner.
If Lordship permits.
Right. In court today, and it has been accepted by him. Full stop. This is without prejudice to the rights and contentions of the parties. Full stop. HPCL has expressed its willingness to extend and renew the lease agreement. Full stop. The parties are willing to negotiate the terms through discussions. Full stop. The parties will appear before the mediation center of the High Court.
As your Lordship pleases, or we can mutually discuss it.
If you can mutually discuss, that's no. Can you mutually discuss it?
We can make an attempt, my lord.
All right. The parties, the counsel of the parties will attempt at negotiation to arrive at an amicable solution and terms on which the lease can be continued in favor of HPCL. To report the further developments, list on. We'll have it in July.
As your Lordship pleases.
Or 5th July.
Obliged.
5th July.
Deeply
We
obliged.
appreciate your effort. Right.
But I had made the statement, my lord.
I know. You've honored it. That's very good.
I'm obliged.
Right.
Deeply obliged.
Right.
Supplementary list item number 11.
11, my lord. This matter relates to denial of promotion under career advancement scheme. Now, during the pendency of the case, my lord, the opposite party 1 and the opposite party 3, they have been renamed as University of it was previously BPUT, Biju Patna University of Technology. Now it is Bir Sundar Sai University, and opposite party 3 is known as Orissa University of Technology and Research, Bhubaneswar. So I need to amend this cost item. Otherwise, I may not get, even if I succeed, I may not get the.
Lordship, kindly see the order I have placed by the Honorable Chancellor, Honorable Governor. The Lordship see next page 5. His name was not considered, Lord, by the.
This is
Dr. P.K. Das. That is, Lord, does not have the CCS minimum qualification 5 years and eligible for his promotion beside his joint alternate service, because the UGC has given a guideline. If he has earlier joined, he cannot avail the CCS scheme. And if as in order has been passed, Lord, I don't think that any amendment will help the petition, Lord.
Correct.
Subject to what also, Lord.
Correct.
No, I was not, what he says, my friend says, I was working. I have given a date chart, your Lordship may kindly, I may allow to place that. Date chart.
All right. Yes, sir.
Yes. 31/12/87.
Yes.
The petitioner was appointed as lecturer grade 1 in the College of Engineering and Technology, Bhubaneswar, a constituent college of Orissa University of Agriculture and Technology, OUT, Bhubaneswar. 12/1/1993. Petitioner was promoted to the post of lecturer selection grade under the said establishment. 27/11/2000, OUT, Bhubaneswar adopted the provision made in the government resolution dated 21/10/2000, Vice Board of Management resolution dated 27/11/2000 for considering placement of promotion in different grades through career advancement scheme. 4/7/2001, while continuing in the constituent college of OUT, Bhubaneswar, petitioner applied for promotion to the post of reader along with the other eligible candidates, including juniors, under career advancement scheme as adopted by the boards of management OUT Bhubaneswar by resolution dated 27/11/2000. Eligibility criteria for reader promotion under CAS each at page 11 of Annexure 2. That is 5.
Be that as it may, pursuant to open advertisement, the petitioner applied for the post of reader against a substantial vacancy in the University College of Engineering, Bulla, in another college, my lord. He applied for against a substantial vacancy. While the matter stood as thus, the state government, by gazette notification, transferred the management of both the College of Engineering and Technology, Orissa, and the University College of Engineering, Burla, to the administrative control of newly constituted Biju Patnaik University of Technology. BPUT officially took over the management of the both above noted college. 10/7/2002, the petitioner got selected and appointed as a reader against a substantial vacancy in the Engineering College of Burla and joined there, keeping 2 years lien from his former College of Engineering and Technology, Orissa. 27/5/2003, pursuant to the application for promotion to the post of reader and under career advancement scheme in College of Engineering and Technology, Orissa. Even after joining as a reader against that substantial vacancy in another university, my lord, he was called pursuant to his application he given for career advancement for the interview.
That is what this decision is about.
I got today just now.
That date is not there in your list of dates. Between these two dates, this is important, sir. What has been handed over to you today?
Yes.
Is a one important date between these two dates. Between 27th May 2003 and 4th August 2004.
Yes, sir.
22/7/2004 is important.
Next is.
Yes, ma'am. On 27/5/2003, he was called for interview.
After which, sir, this has happened. After that interview,
yes,
what you are holding in your hand,
yes,
this has happened.
Yes, but now they say, but in the counter, your lordship will find that they didn't consider my case because I got appointment as a post of reader.
Not only that, sir. Just look at this document.
Yes,
that is one of the reasons. The other main reason is that you do not have CCRs for minimum qualifying period for 5 years.
Yes, I have. Your lordship may kindly see my date chart that I have completed 5 years.
CCRs, sir.
CCRs. Then your lordship may kindly, I'll take your lordship to the scheme, Annexer 2 of my REIT
Kindly see
application.
the
Annexer 2.
counter filed by the PUT and the annexures.
Wait, please wait. Your lordship may kindly see Annexer 2. Annexer 2, page 13.
Yes.
To my REIT application. Career advancement scheme.
Yes.
Then your lordship may kindly come to page 40, next page, reader promotion.
Right.
Reader promotion. A lecturer in the senior scale will be eligible for promotion to the post of reader if he has a completed 5 years of service in the senior scale, then obtained a PhD degree or has equivalent published work, made some mark in the area of scholarship and research as evidence, that is by self-assessment reports or reference, innovation, design of new courses and curriculum and extension activities. After placement in the senior scale, participation to refreshers course, summer institutions of approved duration or engaged in other appropriate continuing education program of comparable quality as may be specified or approved by the University of Grant Commission. Possess a consistently good performance appraisal report. Promotion to the post of reader will be through a process of selection by a selection committee to be set up under the statute ordinance of the concerned university or other similar committee set up by the appointing authority. The promotion for the post of reader subject to availability of vacancies in the senior post of reader. That I have qualified, that I have completed 5 years in senior scale. I have given all these refreshers course details in a appraisal statement. I have self-appraisal statement I have given. Now they say, in counter they say, because I got appointment in the post of reader, so I am not entitled because I was it was due to me in 31/12/1998. I should have get the career advancement promotion in the post of reader in 31/12/1998. But and I got appointment in 2004.
Sir, this 5 is important, sir.
Yes.
What you read in page 14.
Yes, ma'am.
Possesses consistently good performance appraisal reports.
Yes.
Where will this come, sir? Where will you get appraisal?
It's self-appraisal. That is just.
Where will it be, sir?
The candidate has to submit a self-appraisal report before the committee.
Not self-appraisal.
That you'll
doesn't say self-appraisal. Doesn't say self-appraisal. It says possesses consistently good performance appraisal reports.
Yes.
Where do you think you'll find it?
Annexer, your Lordship, I see Annexer 4, page 17. I have given all this in my biodata, all these things.
Sir, I've asked you a question.
Yes.
Where do you think you will find appraisal reports? Where will you find it?
This scheme, your Lordship, kindly appreciate. This scheme provides.
Sir, do you know the answer to the question or you do not know the answer?
Appraisal reports has to be submitted by the candidate itself.
No, sir. What is meaning appraisal? Meaning what? What is the meaning of appraisal?
That scheme provides, madam.
So who will appraise your performance? You are working.
Certainly the authority will appraise.
So it can't be self-appraisal. Somebody has to appraise your performance.
But under the career advancement scheme, that is self-appraisal.
No, sir. You are mistaken. Even for a career advancement scheme, somebody who has watched your work, not self-appraisal. Somebody who has watched your work will appraise your work.
That if your Lordship, I'll show you that your Lordship, I'll show you that the self-appraisal has to be given by the candidate. And that will be placed before a committee of selection committee, and they will pass.
So you have, I'm sure, done several service law matters.
Yes, ma'am.
Have you heard of the term ACR, CCR?
Yes, CCR.
What is the meaning of that, sir?
Check the character certificate, ma'am.
Not character certificate, sir. What is that CCR, ACR for? What is it? You have done service law, no, sir?
Yes.
What is that for? You tell us.
The assessment made by the authority in the end of the year.
Correct. Of what? Of the work.
Work.
So now come to this 5, page 14.
Yes.
It says possesses consistently good performance appraisal reports. Correct?
Yes.
Now will you able to answer? Are you able to answer the question? Now I have given you the answer. Now don't say I still don't know. Where will you find this appraisal?
It's CCR.
Yes. Now look at the comment made against your name.
Yes.
So without this being satisfied, how can they appoint you, sir?
That I have to verify.
No, Pusto, verify. No.
Now, today they are saying this.
Whatever, sir, whatever. You see, the short question that arises for consideration in this repetition is whether the Biju Patnaik University of Technology was obliged to promote the petitioner as reader, as claimed by him, under the Career Advancement Scheme bracket CAS with effect from 31st December 1998. Question mark. The background facts are that the petitioner initially joined the Orissa University of Agricultural Technology. No, it initially joined as lecturer in the Civil Engineering Department at the College of Engineering and Technology bracket CET Bhubaneswar, which is a constituent college of the Orissa University of Agriculture and Technology bracket OU80 bracket on 31st December 1987 paragraph. He was promoted as lecturer bracket senior scheme under the CAS and worked as such till 9th July 2002. He was selected as reader at the University College of Engineering, Burla, bracket UCE, Burla, bracket, under direct recruitment. Full stop. He was therefore relieved from the OU80 while retaining his lien there, as per the order dated 5th July 2002 and subject to the terms set out in the said order. Paragraph. By notification dated 14 June 2002, the Biju Patnaik University of Technology bracket BPUT was established. Both the CET Bhubaneswar and the UCE Budlas were transferred from their respective universities to the OU80 Bhubaneswar. That is transferred and became constituent colleges of the BPUT. Full stop. The lien of the petitioner with the CET Bhubaneswar continued for a further period of 1 year with effect from 10th July 2003. Full stop. The petitioner was permanently absorbed in UCE Burla as a reader. Paragraph. The BPUT conducted a selection for under the CAS, and the petitioner was called for an interview. Before the selection committee on 30th May 2003. Paragraph. The petitioner was not selected for promotion to the next higher grade of reader aggrieved, the petitioner filed the present petition. Stop. In response to the petition, a reply has been filed stating inter alia that once a candidate is appointed to a higher post through direct recruitment against a sanctioned post, he cannot avail the promotion under the CAS. Full stop. The CAS is made available to appointed teachers of the university and affiliated colleges in terms of the Government of India resolution dated, Government of Orissa resolution dated 27th October 2000. Full stop. In other words, since the petitioner was selected as reader on a permanent basis in the UCE Burla, on the basis of direct recruitment, he could not maintain a claim for promotion as reader under the CAS in the BPUT. Paragraph. At today's hearing, P.K. Satpathy, learned counsel appearing for the BPUT, handed over a copy of the proceedings dated 22nd July 2004, issued by the Undersecretary to the Governor, who happens to be the Chancellor of BPUT. To stop this, communication inter alia sets out the names of persons who had been approved for promotion and those, like the petitioner, who are not cleared. Full stop. The reason, as far as the petitioner is concerned, is that he, open quotation, does not have CCRs for minimum qualifying period of 5 years before date of eligibility of his promotion. Full stop. Besides, he has joined alternative service. Unquote. Paragraph. Learned counsel, petitioner contests the above reasons for rejection by drawing attention to the CAS notification dated 21st June 2001. Full stop. A perusal of the said notifications shows that for being promoted as reader, a lecturer in the senior scale has to comply with the following conditions. Take from page 14 of the paper book, Roman 1 to Roman 5, paragraph. The condition at clause single open quotation 5, that is Roman small 5, above, states, open quotation, possess consistently good performance appraisal reports, unquote. For the purposes of fulfilling this criteria, the candidate has to certainly possess the necessary CCRs during the minimum qualifying period of 5 years before the date of eligibility. Full stop. With the petitioner not possessing such CCRs, clearly he could not have fulfilled the set criteria. Full stop. Therefore, irrespective of the petitioner having been absorbed in UCE Burla as a reader on a direct recruitment basis, he even otherwise did not fulfill the criteria of having CCRs for 5 years prior to the date of eligibility for promotion. Paragraph. The court finds no illegality committed by the opposite parties in not granting the promotion to the petitioner to the next post of reader under the CAS. There is no merit in the present petition. It is dismissed as such.
Supplementary list item note 13.
I may be pardoned. I am Samir Mishra through virtual mode. Your Lordship may pardon me, I am through virtual mode. I had filed a compilation of document which your Lordship was pleased to direct me to serve copies on the learned counsel appearing for the contesting opposite parties. I have served. In fact, my Lord, if your Lordship will pardon me, my father is not well. I am suffering from hospital to virtual courts like that. May I pray for a breather today? Because I have not been able to, if I am pardoned to say so, I have not been able to do my homework because of that.
All right. Counsel for the petitioner stated to be in some personal difficulty. This on 24th August.
Supplementary list item note 14.
Obliged, ma'am.
14, I'm appearing along with Sri Gopal Jain. First matter and this second sub-item, in fact. On the last occasion, what happened is the Council for the Railways was the briefs were transferred to the State Union of India. So Mr. P.K. Pari was supposed to appear today.
He's there. Mr. Padi, you're there?
Yes, I'm here, but I'm not taking instruction or anything. Just they hand over the file to me.
Mr. P.K. Padi says that the files have just been handed over to him and he has yet to obtain instructions on behalf of the railways.
Yes, ma'am.
Yes, he has appeared on
behalf of the railways.
In fact, they have filed the counter.
There are interim orders here.
Yes, first matter, 6930 interim orders there.
Interim order in 6930 of 2010 will continue till the next day.
Railway has already filed the counter, in fact.
Yeah, but he's not ready with the matter. It's list on 24th August.
Deeply grateful, madam.
All right.
Deeply. Supplementary list item number 15.
Pursuant to last order, my Lord Senior has filed the reply. So he has admitted also that the blockage which was there in front of the Badambadi police station, that has been cleared. That he has that.
All right.
So that was his main concern because of that storage of all those seized vehicles. There was traffic congestion. That is why the main petition was.
All right.
May I submit before your lordship? I may be permitted to draw your lordship kind attention. This matter appears today as per the order dated 4 April 2022. In response to the said order, I have filed my affidavit, my lord, which finds place at flat A of your lordship's brief, my lord. I may be permitted to place that affidavit which I have filed, my lord.
Yes.
The relevant paragraph of the said affidavit finds place at page 3, my lord.
Yes.
Paragraph 7 and 8, my lord.
Yes.
First of all, I would to draw your lordship kind attention to para 8, my lord.
Yes.
After verification, it is found that the seized material dumped in and around the Badambadi police station have already been shifted, my lord. There is no dispute, they have already shifted. My submission before your lordship is that this matter may lie over and the DCP Cuttack may please be directed to implement the order and direction issued by this honorable court, hide their judgment dated 31st January 2021, passed in WPC number 8. Already your lordship previously also directed. They have to dispose of the seized material. They have shifted and the seized material now has been dumped in the premises of Orissa State Road Transport.
Why are you worried about all that, sir?
My lord.
Why are you worried about all that?
My lord, that should be disposed of, my lord.
That's okay. They will do it. You wanted this congestion to be removed. It's been removed.
That has been removed, my lord, but that should be disposed of.
All right. We'll tell them to dispose it of. All right.
Previous order, that should be disposed of.
All right.
Only my prayer.
All right. The only prayer left now from the petitioner's side is that the seized materials, which were earlier parked outside the premises of the
Badambadi
police station, should be now disposed of. Detailed directions have already been issued by the court for disposal of vehicles and other seized materials under the NDPS Act in a separate proceedings. Full stop. The court has no doubt that the respondent authorities will abide by those directions and dispose of the seized materials. Full stop. No further cause of action as such survives for the court's interference. The petition is disposed of. The petitions are disposed of. Is it? There are two or one?
Another connected matter.
The connected matter is disposed of. All right.
My lord, there is another connecting matter.
That is also disposed of.
My lord.
Supplementary list item number 16.
Item number 16, Your Lordship, for the first matter, I'm appearing on behalf of the petitioner. Lordship, the matter is relating to construction of the railway line from Talchet to Bimalagarh. Your Lordship, we have received a counter affidavit from opposite party number 7, 5, 6, 2 counter affidavits from opposite party number 5 and 6, and 1 counter affidavit from opposite party number 7. Your Lordship, I'll file a rejoinder to the same. Your Lordship, we keep it at a short date.
Shall to be filed before the next week. Just on 25th August.
Lords, I am appearing in the second matter. Lords, we'll also need to file a detailed rejoinder to that effect, my Lords. We have also received copies.
All right. Same order.
Supplementary list item number 17.
May I please, Your Lords? Item number 17, my Lord.
Yes.
May I please, Your Lord? My Lord, this is regarding filling of the posts of president and members on district. Different.
Your president member already, I think it is in process.
Vacancies are there. Many vacancies are there, and many forums are not able to function because of lack of quorum, my Lord. Only one person, either president or member, has joined. So, my Lord, the government should start process afresh to fill up the other vacant posts.
How many vacant posts?
I have seen across that a lot of vacancies have been filled up, and regular all the district forums as well as state commission, they are regularly functioning with full strength. If there are...
Wow, what are you saying, sir? Maybe you're not correctly informed.
Jajpur, Bhadrak, Dhenkanal, these forums are only one persons are there and they are not taking up hearing matters. I shall file an affidavit. Lords may permit me 1 week time, my Lord. Many forums only one. I shall file an affidavit, my Lord. Rejoinder, they file counter. I shall file a rejoinder to that, my Lord.
Counsel for the petitioner seeks and is permitted to file a further affidavit before the next week.
Fine. Okay.
30th August.
Supplementary list item number 18.
Item number 18, my Lord, as per the Lordship's last order, we have received a copy of the affidavit of the Watco only yesterday. So we need to respond to that, my Lord. Lordship may grant us some time because yesterday 150 pages document they gave it.
Okay. It appears that Watco has filed an 150-page document with its affidavit, which needs to be responded to by the learned amicus curiae.
My learned friend has also not got a copy.
I think this is the court. Court just supplied the copy. Court supplied the copy.
All right. List on. We'll have it after the vacation then?
Yes, my Lord.
All right.
May I pray, my Lord, the Watco may supply a copy to the CMC also?
A copy of the Watco's affidavit be supplied to the CMC, counsel for the CMC as well. 13th July, sir. Sir, 1 minute. 13th is all right. 13th.
Lordship, Watco may supply also copy to me, Your Lordship. I'm contracted.
Right. Some affidavit, copies of the said affidavit be supplied to all the other parties. All right.
Supplementary list item number 19.
19, Lordship, today, in fact, in this case, I am appearing and filing a grievance petition, Lordship, in this public interest litigation. I am the present elected Sarpanch, Lordship. The matter relates to construction of a Kalyan Samiti, Lordship. But Lordship, kindly say I have taken affirmation in my interest petition. In the meantime, the Panchayat Gram Panchayat had taken a decision to change the venue, Lordship. In fact, the decision was earlier diverted due to the interference of Didin Sarpanch. Now, nobody has come up, Lordship. Nobody has taken a decision to construct the same community hall in a particular place, Lordship.
All right. So the cause of action doesn't survive.
Cause of action, in fact, Lordship, because it is administrative decision, the collector to take a decision, because we have taken a decision, the collector to implement, Lordship. The collector will implement, nothing to do, Lordship.
My Lord, may I just pointed one thing? In 2017, my Lord, the Sarpanch and the Panchayat body members, my Lord, they decided to construct the Kalyan Mandap in a particular village, my Lord. Now, which was subsequently changed to another village. Now, the presence after the change of Sarpanch, my Lord, now he wants to construct in another village. But the collector has actually initially the collector sanctioned in the second village. Initially it was in initially it was before Gediapalli, my Lord. Now, subsequently, when the new Sarpanch came, in the year 2019, then they decided to construct it in Gopalpur. Now the collector has also approved, the government has also sanctioned for the construction of Kalyan Mandap in Gopalpur. Now what my learned senior is saying, the present Sarpanch, he is now trying to construct it in another village. So in that case, he has to file a separate writ petition, because for that.
Yes. You file a separate one, sir.
Then in fact, Lordship, the decision which has been taken by the then Sarpanch, that was in fact, Lordship, the decision was elsewhere. But by virtue of Panchayat decision, they altered the site. And that was under challenge. Now we have taken a decision, the present body, Lordship, to construct in a particular place. That has to be considered only, Lordship.
Mr. Dalai states that Mr. Dalai, appearing for the intervener in IA 5957 of 2022, states that the present Panchayat body has resolved to construct the Kalyan Mandap, which is originally sanctioned at Gaudapatna.
Yes. And then
to Gopalpur, to Gediapalli.
Yes. Now the present Sarpanch is saying to
village Gediapalli. Full stop. In that way, the cause of action appears to have been altered. And the original cause of action, which led to the filing of the present petition, does not survive. While disposing of the petition and the application, it is observed that anyone aggrieved by the fresh decision to have the Kalyan Mandap at Gediapalli can seek appropriate remedies in accordance with law. All right.
Supplemental list for hearing, item number 21.
May I please, Lordship?
Being aggrieved, the judgment dated 13/2004 passed by the London Additional Session Judge Sonpur in Sessions case number such and such, convicting the appellant number 1 and 2 under section 302 and 34 IPC and sentencing them to undergo imprisonment for life, and further convicting the sentencing all the accused person to undergo RI 6 months under section 323 and 149 IPC and RI for 1 year under section 324 and 149 of IPC and under section 325 and 149 IPC for further sentencing appellant number Jodu, Akshay, Bachu and Ramos to undergo RI for 6 months each under section 437 IPC. But the prosecution case is that one Gurjan Sahu PW1 lodged a written report alleging therein that on 29/3/2000 in the morning at 8 a.m. the accused person tried to close the passage of the house of the informant by pinching it. The informant PW1 along with PW2 to 4 and PW8 to 10 while protested them and objected to such pinching, the accused person immediately brought weapons like axe, spread and lathi, etc. and attacked the informant and their family members. The appellant number 1 inflicted one axe blow on the head of the deceased and he fell down on the ground, and immediately appellant number 2 further assaulted another axe blow on the head of the deceased. While the PW7 Nabin Sahu tried to save him, the appellant number 6, now he is dead now, assaulted PW6 on his head with an axe. He sustained bleeding injury, and appellant number 4 assaulted one Sonu Naik by a thenga, and appellant number 8 gave a lathi blow to PW number 2, and appellant number 10 assaulted one Purnami, daughter-in-law of the PW1, and appellant number 3 hit the daughter-in-law of PW1, and appellant number 13 assaulted the informant with lathi, resulting he fell down on the ground, and appellant number 9 Panchanan, also PW9, assaulted PW9. Due to such assault, the Madhu of the deceased sustained bleeding injury on his head, and he shifted to Rampur PSC, and who referred to subsequent VSS Medical College, Burla, and during his treatment, after 4 days of occurrence, he died on 2/4/2000. And other also treated due to their minor injury. On the basis of the FR, IAC Rampur PS registered Rampur PS case number 8/2000 under section 307, 324, 325, 327, 326, 147, 148, and 34 IPC. But death of the deceased of Madhu, the case was turned to 302 IPC and other offences. And investigation of the same, upon completion of the investigation, the police submitted the charge sheet under section 302, 307, 147, 148, 341, 294, 324, 325, and 336, 427, and 149 IPC against 24 accused persons. In order to prove the charge against the appellant number 1 and 2 and the other accused, the prosecution has examined as many as 16 witnesses. PW1 is the informant, PW2 is the wife of the informant and the mother of the deceased, and PW3 daughter-in-law of the informant, and PW8 another son of the informant. PW4 and 7 are the occurrence witnesses, and PW15 and 16 are the IO, and PW15 is the medical officer of Rampur PSC who has first treated the deceased as well as the other injured person, and PW11 is the lecturer of neurosurgeon, and PW14 the resident surgeon of VSS Medical College, and PW13 assistant professor who conducted the postmortem report, and PW12 is the lecturer of the orthopedics of VSS Medical College. And exhibited 40 numbers of documents, Lord. And the defense, please, Lord.
How many eyewitnesses, sir?
Pardon. Big pardon.
How many eyewitnesses? How many eyewitnesses are there?
Eyewitnesses, my lord. PW
1, 2, 3,
1, 2, 3, 4, and 4, 7. All are
6, 7 also.
So many eyewitnesses.
Yes.
None of them is turned hostile.
No.
But PW1, 2, 3, and PW1, 2, 3, and 8 is the family members. He is interested with this.
So what?
Now, defense, please. Defensively, the informant is good number. On the date of allegation, the date of incident, some of the accused person were repairing their house, which is in existence of the canal acquired land, like of other villages since long. It was claimed that the said accused were having the house over the occurrence spot since long. The informant party is a good numbers with a view to taking possession of the said premises and preventing the main accused from constructing and repair the house, went to the spot with arm and assaulted some of the accused who were at the spot. And due to such reason, counter case has been registered against the informant party, and some of the accused also sustained injured, and that have been proved. In other words, the informant party were trespasser and were the aggressor. And against that, some counter case also registered, Lord.
What are the nature of injuries on the persons of the accused?
The doctor's evidence will tell us that.
Yes, Lord. The doctor of evidence, Lord. PW13, Lord.
On page 182, 182.
On 3/4/2000, I being assistant professor FMT VSS Medical Bulla conduct PM exam over the dead body of Madhusudan Sahu, son of Garjan, village Swanso, being identified the Swanso Pikenaik and Nityananda Sahu and found the following. The switch wood L-sharp of the left temper parietal region in size 8 cm on each arm. On dissection, it was found that the scale inch most of left side just below the switched wound. It was a crucial circular hole on skull measuring 6 cm in diameters of left parietal bone, through which the membranes were visible, and the hole was filled with blood clot. There was subrular hematoma on left hemisphere and subspinal hemorrhage on temporal lobe. There was intracerebral hematoma measuring 6 cm.
Intracerebral hematoma
measuring 6 cm and 6 cm
on the temporal loop and fracture of base of skull of 4 cm. On
bone in middle facial phase. In my opinion, the wood were antemortem in nature with surgical intervention prior to death. The head injury might have been inflicted by head and blunt trauma, and it was fatal in ordinary course.
So there's nothing in the cross-examination which helps you.
Lord, so far as my submission,
See,
Lord,
if it's an eyewitness case, there's medical evidence. That's all one is looking for. Is it corroborated by the medical evidence?
So,
the manner of description of the offense.
So far, my submission is not case under 302. It is case coming under the 304 Part B, because there is a quarrel between the parties and due to some civil dispute, and there was a fight, and to prevent the Lordship, can see page 9 of the judgment, Lord. Para 10.
Yes.
Para 9, page 10.
Yes.
PW1, the informant, and PW2, his wife, and PW3, his daughter-in-law, and PW6, 9, and 10 gave evidence that on the day of occurrence, the accused person were fencing the land in order to stop passage to their house, and hence all of them went to that place of fencing in front of their house and objected the accused person, but the accused person threatened to murder them and then brought out weapons like.
So this is not sudden, sir. They went and again brought all these weapons. So this is not 304.
Lord, it is also discussed by the law and trial court in paragraph 15, Lord.
All right.
It is the evidence of PW1 and admitted case of both the parties that all the accused person excepted accused Khema and his wife Bullu were member of one family, and Bhallu, wife of the accused Khema Bise, happens to the cousin of the Bhagavatia, and the accused Khema was residing at that place of residence. Son-in-law PW1 had admitted in para 2 of his cross examination that all the adult member of the family of accused person previous enmity and litigation in respect to the aforesaid land, Bhagavatia Tandi adjoining the canal aqualand, and it could be proved through investigation officer PW10 that the gear case number 40 of 2000 was initiated against the sum of the witnesses, Lord, relating to that day of occurrence. On the affair, the accused Gelha Tandi, and it intend in charge sheet by Exhibit G against PW1 Garjan and PW8 Nityanand and PW9 and PW10 Makardhaj and another son of the informant under section 133, 341, 336, 337, 139 IPC, alleging that these witnesses assaulted accused Galla, Panchanan, and Hadu, etc. It shows that there is free fight between the parties, and during the free fight, the tribal defense, the present appellants has attacked the.
If any of the accused persons assaulted
No.
from the side of the informant, what are the injuries? What are the nature of injuries they have sustained on account of the assault?
Injuries to the accused.
Injuries to the.
As you claim that the prosecution is required to explain the
injuries on the
injuries on the persons of the accused.
Which doctor examined the accused?
That accused, no, that has not been discussed in the judgment, but in paragraph 15, it has been discussed that there was a free fight between the accused and the appellants.
No, free fight means accused also should get injured, sir.
Thereafter,
you have to make good your alternative theory, no? You put forth an alternative theory, you have to make good that.
Thereafter, my lord, the trial court has discussed for their medical examination. As already mentioned, PW5 has medical examine, and the aforesaid person found one abrasion each of the accused, Hadu and Panchanan, had exhibit A and B.
That's only an aberration.
It's not.
All right.
And one laceration each on the person of Bhalu and Alice Khema and Gahala and Bhimala by exhibit C, D in view of such material contents was made that the prosecution case should be viewed with suspicious. Such in a is not permissible. It is law is well settled that on the ground of interestedness and
two persons have been convicted for the offence punishable under section 302 of the Indian Penal Code. And race plus all have been convicted of 323, 325, 149 like this plus 6 months, somewhere one maximum punishment is 1 year for them.
Correct.
So two Bibha and Bibha Tandi and Khema both have been convicted under section 302. My learned friends should focus on those two persons, and they are the principal assailants. And there is eyewitness.
And they were both armed.
Yes, both are.
And the two deceased persons or one?
One plus, and rest are injured. All injured eyewitnesses.
All right.
And they are the aggressors because they put up a wall in front of the passage.
Correct.
That is the reason why they reacted.
Right.
With regard to the injuries on the accused persons, it has been discussed in the impugned judgment in para 20. Kindly go through.
Mine is aberrations and lacerations. How many of these eyewitnesses are interested witnesses?
Yes, because they are all family members.
All a family.
All are family members. Mother, sister-in-law, and one brother of the deceased plus. They are the eyewitnesses, and also another brother is the eyewitnesses.
The paragraph 20, the learned counsel for the defense has all that the fact and circumstances would reveal a case at best free fight, and therefore the offense under section 147, 148, and 149 IPC would fall. He further contended that the materials on record when compared with the defense story as put forth in the counter case, FIR Exhibit F and the injury sustained by 5 accused persons under Exhibit A and 2E would reveal a case of right of private defense of property, and therefore the offense under section 302 and other charges would
Come
not.
to the last part. Come to the last part of the para 20. Injury sustained by the members of the prosecution party are grave and serious in nature. In contrast, the injury sustained by 5 accused persons, simple and negligible.
In this case, the principal laid down in the case state of Gujarat so and so were also proved at the cost of repetition. It is to be stated that the aberration sustained by accused Khema and Panchanan on the right ear are minor and insignificant to be noticed by the witnesses in a gathering hole. One of them was beaten to death, and similarly, the laceration of Hema BC are her scale and Gelhitandi on her right arm and Bimalatandi on her right foot could be hardly noticed in similar situation. This minor injury do not only a case of free fight nor support the story of attack by the prosecution party. The chance of being sustained such injury during stone plating cannot be ruled out. Fact and circumstances would bring out a case of third category of the principle that it does not affect the prosecution case as held in case of state of Gujarat versus such and such. In this fact and circumstance of the scene, no interference can be drawn that the accused person had inflicted the injury on the member of the prosecution party in exercise of the right of self-defense. The injury sustained by the member of the prosecution party are grave and serious in nature and in contest. The injury sustained by 5 accused persons, including 3 women, are simple and negligible and can have been otherwise explained. As already held, it does not come out a case of a free fight. Right of private defense to demolish the charge under section 149 IPC and other offences. The citation placed in support of the contention, therefore, are not applicable to the fact and circumstance of this case. Next contention is that it is a assault not proved, my lord. But PW1 in para 1 accused Vibhatandi Khema BC gave one asked law on each disease of the Madhusau. And PW1 in para 5 says that I could not notice if the blow was from sharp side or blunt side. And he has also stated in 161 statement that the assault was from the sharp side of the axe.
So the injuries themselves will show us with sharp side or blunt side. Injuries themselves will tell us, sir.
No, para 5 has said that I saw accused Biba assaulting my son Madhu by axe. Then next line my Latin friend is reading, I could not notice if it was in the sharp side or blunt side. He assaulted Madhu from his side. I described Tangia Chot as inflicting a blow in the sharp side of axe.
Doesn't make a difference anyway. The man is dead. Yes.
So PW2 in para 1 accused Biba inflicted a cut blow on the head of the Madhu and accused Khema gave a blow by blunt side. And PW2 also contended it was confirmed to him that he stated to IO regarding the assault from the sharp side, Lord. And PW3, Lord, accused Biba and Khema gave one blow each. In para 2, it was confronted that he stated to IO that the result was by sharp side of the axe. And PW5 is the doctor, and in para 5 he stated that he found only one injury on the head of the Madhusau, and the report has been marked as Exhibit 6. And PW5 in para 12, there was a single injury in Exhibit 6 belonging to Madhusau. In para 12, last statement he has stated that such type of injury is also possible by accidental fall on hard and rough surface. But in para 15, a disposed sharp of the injury cannot be ascertained by number of blow. If 2 blows caused the injury by Exhibit 6, it cannot be said which blow was fatal. And in PW7 alleged 1 blow each by both the accused. PW8 in para 1 deposed that accused Biba and Khema gave 1 blow each from the blunt side. In para 2, it was confirmed to him that he made allegation of assault by the sharp side of the axe. In oral evidence, Lord, it used to be followed, my Lord, that informant and other witness during 161 statement made allegation of assault by sharp side of the axe by accused Biba and Khema. Even if the FR was lodged in presence of all the prosecution witnesses. Allegation was not made in the FIR regarding assault of the Khema BC to the deceased Lord. But all the doctors found one injury on the head of the Madhu. But doctor deposed that the internal injury corresponding to the said external injury, and as per evidence of PW5, in the event of more than one blow, the sharp of the injury cannot be ascertained. But in the case in hand, the so-called injury on the person of Madhusudan Sahu was L sharp. It is in the evidence of doctor that the said injury could be possible by fall and by blunt object and not by sharp side of the weapon. The submission is factual. The allegation of the assault not proved due to contradiction evidence. Contradictory due to non-examination of the independent witnesses and due to conflict between the ocular evidence and medical evidence.
PW4 is an independent witness. PW4 is an independent eyewitness. He has stated, I am reading the relevant portion. Accused person faced the land closing the passage to the house of the informant, and hence PW1 objected. I was present there. I saw accused Bibha and Khema assaulted Madhu by axe. Nabin was assaulted by Kirtan Tandi. There was Pohala and further assault, and hence I went away. This is an independent eyewitness, not a family member. And also, PW7 is another witness. Even not being the family members of the deceased, I know the accused person and PW1. On 29th March 2000 morning, I was going to bring straw and found accused Bibha and Khema inflicted axe blows to Madhu Sahu. Accused Kirtan and Binod assaulted Navin. All the accused persons assembled there and assaulted others. So specific allegations are made by the independent eyewitnesses as well as the eyewitnesses who belong to the family members of the deceased. And they are the aggressors, the accused persons. They close the passage for which everything has happened. Maybe a civil dispute.
So non-examination of the material whose presence is spoken to try PW at the spot, my lord. So no effect by the IO to examine neighbors. Adverse inference can be done against. Sole independent eyewitnesses examined 5 days after the incident without any explanation of such delay.
Plus, IO has been put to cross-examination, which is available at page 187. For a moment, the Lordship can peruse paragraph 5. Page 187 plus. I have examined PW1, Garjan Sahu informant. It is true that he had stated before me that accused Bibha had inflicted in the sharp side. The IO has stated. And paragraph 6, I have examined PW2 Surish Sahu. He has not stated before me that accused person raised a fence closing the passage to his house and that assault was made in the sharp side by Khema. But paragraph 7 has stated, I have examined PW3 Purnima. It is true that PW3 had stated before me that cord blows were inflicted in the sharp side of axe. At paragraph 9, plus I have examined PW6 Nabin, another injured eyewitness. And plus 3 lines after he has stated, it is true that he had stated before me that accused Bibha and Khema inflicted cord blow on the sharp side. So I have stated. And PW1 plus right from PW1 to 3, the salient pictures just I am bringing to Lordship's kind notice plus at page 150 PW1. I am reading paragraph 1. I know the accused persons on 29th March 2000 at 7 a.m. The accused persons closed the passage to go to my home from the road by raising a fence with the help of bamboo, twigs, thorny bushes. So myself, my family members and my neighbors objected to it, but accused Bhagavatia, Bibha, Uttam, Hadu, Kirtan, Gop, etc. yelled, Dharo Solago Pitma Marma. So we will assault and will kill them. They brought weapons like axe, spear, and lathi kept in the cowshed of Bhagavatia. Accused Bibha Tandi inflicted one axe blow on the head of my son Madhu. Madhu is the deceased. And Bibha Malas has been found guilty.
Two life sentence persons are Bibha and Khema.
Bibha and Khema.
Ah. All right.
But there is a contrary who has attack in Blount State and who has
Does it make a difference, sir? With 34, man is dead now.
Yes.
As long as there's one deep cut wound on the scalp, I don't think anything else matters. There are 3 injuries in all on the deceased. One is a scalp injury.
Well, the trial court is quite kind enough that has left out other accused persons from the purview of section 302 of the Indian Penal Code. And we have not prepared any appeal.
It is admitted fact that there is a dispute between the parties due to civil dispute, and it is also paragraph PW1 in para 2. He has categorically stated that village roads runs in front of my house in east to west direction, and my house adjoining in south canal and adjoining the road to north, and 5 links of lands acquired by canal department adjoining the canal in north, 4 house of the Raghu, Kartiko, so. And from such evidence, it is clear that there is no scope of any road over the canal acquired land, acquired spot to the house of PW1, because the house of PW1 situated towards southern and the spot is towards northern. Intervention by the public court, the para 1, PW1 para 2, the house of all accused person are situated near my house and the spot. The PW1 para 7 and the evidence of IO reveals that the PW1 in the FR and 161 statement have not stated about the raising of fence and closing the passage to his house. In the other word, during evidence, PW1 is making new allegation that PW2 para 2 not stated to IO about the raising of fence and closing of passage. But PW6 was examined on different date. After examination of PW1 to PW5, he made a new allegation claimed to have been purchased a site from Trinath Maji and to have constructed a house in para 2. He made allegation that the accused constructed a fence closing passage to that house. And PW6 in para 4, Trinath Maji owns paddy land adjoining the canal acquired land behind the house of Raghu Sahu and Kirtan Maji, Basu Naik, Sudama, so. It was at the time of purchase and it was cultivable land, and he has not stated to police about the construction of any house over the land, and police has not seen the house. But PW para 3, PW10 para 3 has not stated the IO about the raise of fence. But para 3 middle accused person were constructing a house on the canal acquired land on the date of occurrence. And for them, for the aforesaid evidence following is apparent, my lord, accused Bhagavatia, Litter, and Kirtan were constructing a house on their enclosed land. And it is admitted by the witnesses that the accused Bhagavatia and other villagers were having house since long. And the canal acquired land, which is the spot situated towards north of the village road and the house of the informant, other towards south of the road, thus there is no question of any passage and no question of any obstruction. Thus, it is submitted that 137 has got no application because construction of the house over the land belonging to the government land, which is enclosed since long, is not illegal, and that cannot be done as unlawful object.
That's it. All right. Orders reserved.
Lords, may I be pardoned, Lords. I am appearing on behalf of Mr. Panda for appellant number 5. may I be permitted to place on behalf of appellant number 5?
Yes, yes.
I have written a short note if your lordship may find at flag N.
Ah.
Here I was also charged with 26 other persons with offences under section 302 and 307 and other allied offences, but was acquitted of the 302 and 307 offences, and I have been sentenced to undergo 1 year 6 months, 1 year and 4 years, and other substantive sentences under sections 148, 323 read with 149, 324 read with 149, and 325 read with 149 of the IPC minutes. So
Yes.
far as my lords are well conversant with the facts of the case,
Yes.
if my lords may see flag and written notes, I've categorically stated the manner of assault as well as the implication of the appellant number 5. So far as PW1 is concerned, my lords, who is the was not implicated the present appellant number 5 in the FIR as well, but has come up with a different story altogether, stating that I had assaulted one Nabin with a lathi without specifying where the blow fell. And subsequently, in his cross-examination, he has stated that I had assaulted with an axe, my lords. In his chief, he has stated to have assaulted him with a lathi, and subsequently has come up with a cross-examination to have stated to have assaulted with an axe. And PW2 is the wife of PW1, my lords. She has not attributed any kind of injury.
Named in the FIR. Named in the FIR. Was he named in the FIR?
Let him finish. Let him finish. Yes, Mr. Vanda.
So far as PW2 is concerned, who is the wife of PW1, and there has been no attribution so far as appellant number 5 is concerned towards any injury to have been caused. And with the PW3 is the daughter of PW1. Here she has also not stated about any kind of assault to anybody by the present appellant number 5, my lords. PW4, as my lords know, is the doctor, is the independent witness, my lords, eyewitness who has also not named me, my lords. Lords, PW5 is the doctor who has stated about the wound that has, the injuries that have been sustained by Nabin Sahu, my lords. That is one incised looking lacerated injury over the right parietal region of the scalp, 2 into 1 inches, and was referred to the Bulla Hospital. My lords may see page number 160 of the paper book. He has stated, my lords. And in the cross-examination, he has also agrees that the injuries are possible by the fall, depending on the circumstances. If my lords may see the cross-examination. Lords, at para 13 of the cross-examination.
Yes.
Lords, so far as PW6 is concerned, my lords, he is the injured person, Nabin Sahu. He is the son of PW1 who has stated, was given the FIR. He has stated about his assault on his head by one Kirtan and the appellant with a lathi on his backside, my lords. And he has categorically denied, if your lordship may see para 6 at page number 186, my lords, he has denied stating before the IO that appellant assaulted him on his head with a lathi and has stated that he has sustained swelling injuries on his back, my lords. May I place that, my lords?
Yes, yes.
My lords. Para 6, my lords, page 186, my lords. I have examined PW2, Suruchi Sahu. He has not stated before me that the accused person raised a fence closing the passage to his house. Well, it's para 13. I'm sorry, my lord.
Yes, sir. I am answering to my learned friends, sir. Argument. PW6 is the injured eyewitness. Plus, now at page 167. Plus 4 lines down from the top. Accused Binod hit my back by lathi. I fell down.
My lords, may see para 6, my lords. It is not a fact that I have stated before the police that the accused Binod assaulted me on my head by lathi. I sustained injuries on my back, bracket swelling, my lords. Page number 168, my lord.
Page 167, accused Binod hit my back by lathi, I fell down. Because now I am drawing to Lordship's attention to page 188. The IO has been confronted with the statement 88 plus paragraph 9. 188. Last two lines. He had stated before me that Binod assaulted him on his head by lathi.
So may I place that entire para, my lords? Para 9.
Yes.
But I have examined PW6 mapping. It is true that PW6 has not stated before me that they had purchased a piece of land from Tirthamaji and has constructed one house in that purchased land. It is true that he had stated before me that the accused Vibhananda Khamma inflicted cut blow in the sharp side. He has not stated before me that after the assault by Vibha, Madhu fell down and thereafter Khema assaulted Madhu by axe. He had stated before me that Vinod assaulted him on his head by lathi.
And my friend is appearing Binod.
That is the only thing. And so far as other accused persons are other PWs are concerned, PW7, who has also been stated to have been an eyewitness, has stated that Nabin was assaulted by Kirtan and the appellant, but without specifying the manner of assault. If my lords may kindly appreciate the fact, my lords, he is an eyewitness. And being an eyewitness, he could not state, my lords, as the manner or the side or the part of the body in which the assault has taken place, my lords. Then PW8 is the son of PW1 again, my lords, who has implicated Kirtan to have assaulted Nabin and the appellant to have assaulted with a lathi, but has also not stated the manner in which it has been taken place. And in cross-examination, he has stated, my lords, that the appellant has inflicted lathi blow on the head of the Nabin. But in the chief, he has not stated as to the fact that it was on the head or where, my lords. But so far also he admits that they were all, that he is facing a case under GR 40 of 2000 on the allegations that at the time of occurrence, he and others had assaulted some of the accused persons and damaged their house, my lords, at para 3, my lords. PW9 is one Janma Naik who has implicated Kirtan, my lords, who and the appellant as well to have stated a blow with a lathi, but has also not stated in the chief as to the manner or place of assault, my lords, on which part of the body, my lords.
All right. That is at page 160 plus PW5 was examined the injured at paragraph 2. Similarly, on that day, I also examined Nabin Sahu, PW6. Son of Garjan Sahu, to find the inside looking lacerated injury over right parietal region of the scalp of size 2 inch into 1 inch into 1 inch. So he has received injuries and he has been assaulted plus as has been said by PW6, Nabin. And also the IO has, while being confronted, he has stated, already made it clear that the witness has stated before him that he was assaulted by the present witness.
All right. Some of the witnesses have, my lords,
and he has been named in the FIR. Vinod Bisi has been duly named in the FIR.
Some of them have
323 plus he has been convicted under 323, 325 and 148.
All right. In view of the inconsistence of the fact that the manner of assault as well as the place of arrest,
Did the other co-accused all are on bail?
Plus 3 have died. Other persons plus
are bailed.
They're all on bail. All right. All right. All right, sir. Orders reserved.
The file any written?
Next fact.
Supplementary list item 22.
My lord, please. My lord, in this case, my lord, I have been engaged by the I have been engaged, my lord, and now paper book has not been supplied to me, my lord. My lord, my candidate.
No, this is a very sensible.
Paper book may be kindly directed to supply the paper book, and so also I will argue this matter next week, Monday or Tuesday.
He is available in his village. He has been released on bail. He is available on his
So
village.
he's engaged this man. He's appearing for him only. He's appearing for him, sir. Counsel is appearing for him.
My lord.
Counsel for the appellant states that he will collect the paper. You have to collect it, sir. He will collect the paper book and get ready with the matter next week.
Oblige.
List on. June.
Supplementary list item number 23.
That's in item number 23. May I beg to submit one thing? That's I am appearing on behalf of Mr. Panda for the respondent here. This is a government appeal, my lords.
Yes.
And lords, this has been mentioned. So far as the mentioning having been done, we have not been duly intimated about that mentioning, and we have not received the paper book also.
The paper book has not been prepared in this case, my lords.
It has not been mentioned at our instance, my lord.
All right,
Not
the paper
any-
book. All right, the paper book to be prepared and supplied to the counsel of the parties positively within 4 weeks. List on 7 July, sir.
Supplementary list item 24.
24, my lord. And submitting on behalf of Mr. Sahu that in this case, my lord, paper book has not yet been supplied.
It's all ready. Paper books are ready.
Yes, yes. Your lordship may direct the registry to supply the
Okay, paper books be supplied to counsel of the parties.
Unconnected up in my lord 321 of 2011, my lord. I am appearing for the earlier I was appearing on behalf of the appellant. Now the appellant has taken consent and my learned senior is appearing. Mr. Kotikia. 24 जो connected appeal अपन appeal
30th July.
No, 24.
My name be deleted, my lord. Obekar pada be deleted, my lord. Because my
List
name
on-
be deleted.
Yes, 24 was I was appearing. Notice may be issued to the-
List on 21st July.
My name be deleted, my lord. Obekar pada be deleted.
Supplementary list item 25.
Item 25, my lord. For implementation of Annexure 3, this PIL is filed for restoration of the land of Lord Jagannath Puri in favor of the temple authority in the district of Jaspur. Kindly take a glance to Annexure 3 at page 37. The government through member board of revenue take a decision, the last para, page 37. After threadbare discussion, it was resolved that the collector will move government to revenue and DM department to place the matter before the government of their decision regarding recording of Jagannath Road Fund land in favor of Sri Jagannath Mahaprabhu Vijay Puri Marfat Sri Mandir Parichalana Committee. It is further decided in the meeting that the temple administration shall write letter to the collector collector of Baleshwar, Bhadrak, Jaspur, Khurda and Puri to find out such land available in their district and to take such action as in case of collector Kotak. This decision was taken in the year 2006. So far as the land under Kotak district is concerned, the collector Kotak has taken the decision, moved the government and restored the land in favor of the temple authority. So far as this case is concerned, it relates to the district of Jaspur. Since 2006, I mean this resolution dated 24/8/2006, no fruitful action has been taken by either by the government or by the temple authority to restore the Jagannath Road Fund land in favor of the Jagannath Temple Puri. Kindly, so far as
what purpose is this PIL served, sir?
PIL is for restoration of.
What purpose has it served? The last 5 years, what has happened?
In last 5 years, though the case is pending, but the authority did not take any action.
So what purpose is it serving, this kind of PIL?
Because I want that these devotees want that the properties of Lord Jagannath should be restored to the
Where are the
temple
properties?
authority.
Where are the properties?
Properties as lot number schedule A. The properties list is there.
But who is in occupation of that property? Who's under occupation of that property?
Properties are now in the name of government, but some land grabbers are possessing few properties.
No, no. Where are they? Who are they? Where are their names? Have you implemented them?
Nothing specified. Because they are not recorded owners, so they are.
You don't have to make them parties.
No, I have not made them parties.
Without making them parties, how will you evict them, sir?
It is the government recorded in name of government. Prior to that, the land was recorded in the name of temple authority.
Sir, I'm asking you something else. You are saying something else.
My lord, the properties originally belonged to Jagannath Road Fund. It was recorded in the.
What was my question to you, sir?
My lord, I mean, pardon, my lord. I have not made party to those people. I mean, pardon, my lord. Again, my lord.
The persons who are in possession of the lands, they have not been made parties in the case.
I may be allowed to make party, my lord.
Who are they, sir? Are you even aware of it?
No, I
are you even aware who are in parties?
No, I am not, particularly I am not aware.
What is the point of this kind of litigation, sir? You're not aware of the parties, you're not prepared to do any homework, you've simply filed a petition. The petition is pending for so many years, nothing is happening, nothing will happen also. Persons who are occupying land which they are not supposed to occupy, unless you make them parties, how will we get them evicted?
The government has to take the action.
Everything government has to do, sir, but do you have to do something or you have not to do something?
Yes, I will.
You withdraw this petition, you first find out who is under occupation of which property, you give the names, you say property A is occupied by X, Y, Z, then you make them parties, then ask for specific directions. Not like this.
Some name of some people is there in the Annexure 7, madam.
Sir, we can't proceed like that, sir. You'll have to find out their addresses. You'll have to make them parties. You have to serve notices. They have to be heard.
I will amend, my lord. I will amend.
No. You file a fresh petition. You'll have to make amendments also, sir.
I will amend.
You withdraw and file a fresh petition. You say without naming the so-called encroachers on the properties stated to be belonging to the deity. The present petition has been filed seeking their eviction. Full stop. Unless the so-called encroachers are actually named in the petition and specific governments are made and they are served and notices are served to them and they are heard, orders cannot be passed as prayed for. Consequently, in the present form, the petition cannot be entertained. Nevertheless, it will be open to the petitioner after doing proper homework to ascertain the names of all the encroachers and then seek to file a proper petition, impleading them as parties. The petition is disposed of the above terms. Right.
Awesome. Supplementary list passed over matter item number 2.
My lord, that this is that prawn farmer, prawn dairy matter.
Yes.
Your lordship, this petitioner took lease land of one Sukadev Swami and his brothers and dog ponds and a farm was created for prawn culture, my lord. He applied to DLC. DLC recommended his case to the Coastal Aquaculture Authority and Coastal Aquaculture Authority approved his application, granting a registration, and only registration certificate has not been issued, my lord. And at this stage, the authorities wanted, the government wanted to government wanted to, my lord, evict him. So I filed an intervention petition before this honor court, my lord. This honor court, by order that my intervention application number is, my lord, (3573) of 2022.
Yes.
At page 18 of the brief, it has been mentioned, my your loss is directed. I am by the order dated 4/4/2022 at page 14, my lord.
So 10 days advance notice they given you.
Advance notice, and that DLC and aquaculture authority, they shall dispose of the application within 1 month, my lord. Before 1 month, my lord, they have disposed, they have given the application, my lord, placing the permission granted, my lord, under annexure.
Let him file a reply, sir. Let him file a reply.
Now they have issued 10 days notice prior to 1 month, my lord, and when the aquaculture authority has granted me permission, only certificate is to be issued under annexure 2, my lord.
So Monty, till you don't take precipitate action till the next date.
My lord, after the annexure 2,
yes,
it seems that the district committee of Kendrapada is further.
No. Aquaculture authority Chennai has granted approval. I am placing that with reference to our district DLC recommended by letter number 2638 dated 29/12/2021, and then aquaculture authority, coastal aquaculture by letter dated 12/1/2022 intimated the petitioner. With reference to above, I am directed to convey the approval of the competent authority to recognize your farm located at Loaga. Now it is Jagannathpur farm. Village Rajnath Taluk, Kendrapada district, Orissa, for shrimp culture in tandem with the recommendation of district level committee DLC of the Kendrapada district.
What I beg to submit, your lordship may kindly see annexure 2 is in favor of Chittaranjan Parida.
Yes.
And annexure 4, the eviction
my
notice,
lesser.
Brajokishore Swai, Sukadev Swai, and Brahma.
Lesser, I have given the agreement under annexure 1. On the basis of that lease agreement, I have annexed lease agreement under annexure 1, my lord. That is the land which agreement your lordship kindly see page.
No, but why are these persons not parties?
No, they have. I have taken the lead, my lord. You will also kindly see page 11, my lord.
No. Notice is issued to whom, sir? Because
to my lesser, my lord. To my lesser. But I have constructed farm. I have applied aquaculture authority on that land has granted the recognition.
And the petitioner before your lordship is Chittaranjan Parida.
Yes, I have taken it
and
lead under annexure 1.
Notice was not issued to him.
That is my
notice
farm
was
now.
issued to 3 other persons
who are his landlords.
Because no, not landlord. He is saying there is a private agreement between them.
Private agreement in between landlord and the present lessee.
That
the present petitioner.
No. Is it a lease deed? Where is that lease deed?
Lease deed under annexure 1, my lord. I have
a recent lease deed of 2021 December.
Subsequent to 27/12/2021, I have taken the lease. The agreement was issued. Plot number is there, 449. Your lordship will come to annexure to lesson 449, 1 acre 49. I have taken 449, 1 acre 14 from the village Jagannathpur, my lord, Moja Jagannathpur. That I have applied on that land. DLC recommended on the basis of my lease, my lord. And the Coastal Aquaculture Authority approved for recognition, my lord. Now, how can they, my lord, they evict me from that, demolish my carry? It has already been accepted by the Coastal Aquaculture Authority, my lord. To grant a registered certificate is only to be issued, my lord, by in the next meeting.
What is this notice in Orissa?
Plus, section 13, my lord, of the Aquaculture Authority. Section 13.
There's no
registration for a coastal aquaculture. I'll have your lordship. Your lordship kindly.
Orissa documents, the goal of the translation. Huh? It's not marked. There's no defect marked.
May I give the provision of the?
No, what is the notice say? The notice is only that you should not have prawn culture. That's it. Not that you're going to be evicted.
No, who evicted, my lord? That is language. They say that it is illegal. It is not illegal at present, my lord. Aquaculture authority.
ବନ୍ଦ କରିବା ନିମନ୍ତେ ନିର୍ଦ୍ଦେଶ ଦିଅ. So they have noticed to stop.
My lord, I am placing my lord.
And another thing is that your lordship may kindly see the annexure, very peculiar. Annexure 1 is the so-called agreement. First party is Sukadev Sai, second party is
Yes, my
Chittaranjan
lord, that has
Parida.
been allotted to me.
That is the signature of Chittaranjan Parida is not there in the agreement.
Agreement. Here my Chittaranjan in the first page, at page 9, lordship kindly say my signature is there. And at last page, my signature is there. First page, my signature is there.
Kindly see the last page, para 11, where his signature ought to have been placed. Para page 11.
First page, I have put my signature.
No, first page in the below the photograph, but not at the place where you are supposed
No,
to sign.
on side, I have put my signature.
No, there is no signature in the side also. Kindly see. Chittaranjan Parida. Page 10, page 11, there is no signature at all.
Page 9, that signature is
Page
there.
9, below the photograph, there is a signature, but the place where.
No. On the right side, there is a signature.
The right side is.
Right, but the place where the last
That my
page,
owner, landlord have not disputed.
they should have come.
They have given that original notice to me. That has been, my lord, accepted by the aquaculture authority. It is not illegal prawn culture at all. Can they demolish it, my lord?
Unless DLC gave
Below the photograph. The right side is.
They say it is an illegal prawn culture.
Let me take instruction, my lord.
Signature.
And then again, they have violated your lordship's direction also.
Your lordship may kindly direct me to take instruction, and it may be tagged with that case. Because this flowing from the same cause of action. So this case may be tagged with 7449, and on the next date I will get instruction.
When
What
is that listed?
Pardon?
When is that listed?
That is
23rd June.
29th.
29th June.
29th June.
23rd.
23rd June.
But what happens in the meanwhile? Interim, his whole worries about the interim.
My lord,
I am maybe
because
protected.
if one person is giving any liberty of this type of liberty, then many others will come.
No, my lord,
Because
I
we
am
have
not.
stopped.
My lord,
This
permission
is
has
the-
already been granted.
Permission is not for this land. That I will give.
This land, Jagannathpur, there is permission. You lordship kindly say Jagannathpur. This land is at Jagannathpur.
We can keep this next week, you find out.
Oh, Miller.
Counsel for the opposite party, state, 6 time for instructions. List on 12th.
Yes.
My lord,
On my 12th and 13th, my lord.
No,
12th I
it
will
may be
absent.
relative because on 11th, because from 12th I will be on leave. 11th.
11th.
Yeah,
All
I will
right.
not take.
11th. All right.
Pastor matter item number
Well,
6.
interim protection till then.
So if something happens, we'll come back
is
here.
why-
My lord, they will
Short
demolish
date is
enter my
fixed.
pond, my lord. Status quo as on that shall be maintained, my lord. I
That
am
is
not
why
praying
short date
anything.
is fixed. Your
I am
lordship
not
has
praying
fixed the
anything.
date.
Status
Because
quo
I
as
will
on
get
that.
the instruction on 11th.
On
Your
11th,
lordship
my
can
status
dispose of
quo.
it.
Till then, no coercive action, my lord. Till then, no coercive action.
There is no coercive action. You have
Then
been,
you will
you have been
demolish, my lord.
instructed
Can
to
wax, my
stop
lord. If
the
you demolish, I will
pisciculture.
lose lakhs of
Question of
rupees, my lord. I am a young
No, there's
entrepreneur.
no demolition, sir.
There is no
Only been asked to
demolition.
stop.
They will demolish, my lord. Your lordship grant me status
But that
quo
is
till
not
then.
the notice.
That
This
is
is
the
your
notice. That
submission.
is not true.
Notice nowhere
They say, my lord,
says.
illegal prawn.
Anyway, you tell them we'll issue notice on the stay also. All right.
Yes.
Notice on stay, you tell them it's pending. All right.
My status quo till then, my lord.
No, we don't
No
want.
coercive action till 11.
No, it's all right. Call it on 11th. Yes.
Supplementary item number 6. Item number 6.
Item number 6, my lord, let it be tagged to, my lord, let it be tagged to the my lord, connected matter, that is WPC 14078 of 2020. It is with regard to challenging the notification of rehabilitation assistant.
Just a notice. You accept notice for whom, sir?
Sir, notice, my lord, notice for Director Secondary Education, District Education Officer, my lord, opposite part no 3, 5.
All right. He accepts notice for 3 and 5.
3, 5, 1, 3 and 5, my lord.
1, 3 and 5.
Yes, my lord.
But 2 is also GA department only, sir.
That is the government. I am from the School and Mass Education Department, my lord.
All right. Mr. Mudli accepts notice for 2 and 4.
Will also direct to serve the copy because he has not served the
Copies be served. List along with writ petition civil.
It was writ petition civil 14078 of 2020.
14078 of 2020 on?
Posted to 7th July 2022.
All right. 7 July 20. All right.
Oblige.
We'll come back after lunch. Right.
Filing some affidavits, Lordship, and take it on record.
Supplementary list item number 20.
Mr. Padi?
Yes, my lord.
Tell us.
Yes, my lord. This is instruction I received that they fix up the date for hearing of all the parties on 6/5/2022 at 3 p.m. my lord.
Excellent, excellent.
Yes, my lord, if they provide the details, then I can also extend their help. They can to whom they contact, and they most probably the concerned joint secretaries, additional secretaries who have in charge all this issue.
Right.
They will definitely take care of all these things, and they will be personally.
All right.
Mr.
Mehta, that's an excellent development for you.
I bow down to that, my lord. I was going to, my lord, thank my learned friend, my lord, for taking that initiative, my lord. I have only one request, if your lordship would oblige me, my lord, because your lordship would recall on 2nd, I had made that request after going through MCL's affidavit. They were actually saying that coal is available. The issue is with the railways because there is a non-availability of rakes, if your lordship would recall. And I made that offer, my lord, that I'm willing to partially lift, my lord, during the interim period till, my lord, a workable solution is, my lord, worked out. My lord, by road, if your lordship would recall, because MCL says in its affidavit at page 10 that I've given this option. Now, my lord, I've written 2 letters to them, my lord, saying that since you have this option available, please allow me to do that. But there was no response from their side. But today in their affidavit, they are saying
that kindly see my counter millers. Page 2, I have given a table how much I am supplying in the road mode millers. I am supplying in the road mode millers. My capacity is you are supplying through road mode is 1.5 lakhs to 1.6 lakhs millers, including all the consumers, like 300 around consumers millers. Plus, if I supply more than that, plus other consumer will be.
No,
fall
my
under
learned
difficulties,
friend,
my lords.
I
So
don't
that's
know
why, my
whether my
lords,
learned friend.
let the decision may be taken up by the ministry, my lords. Thereafter, lordship decide whatever decided.
My Lord, with great respect, my Lord, I don't know why my learned friend is backing out from what he has said at page 10. He has given me the option at page 10 of his own affidavit, my Lord.
All
Please
right.
look at,
I am supplying that, my lords.
please see page 10,
No,
my
this
Lord.
is rejoinder. No, no, MCL.
First, see the page 10 of the counter, my Lord.
My lords, first page 2, your lordship see page 2, my lords. I am supplying in the road mode also. Lordship
My
see.
friend will have, my learned friend will have patience, my Lord. Let me just point out page 10, second paragraph. It is further submitted. In view of large number of arrear rakes, I'm so sorry, my Lord. I'm reading page 10 of the counter affidavit, my Lord. This is running para 9, my Lord. It is further submitted in, I'm sorry, your Lordship has the counter affidavit of MCL, my Lord. This was filed on 2nd, my Lord, if I'm not mistaken. Kindly
Yes.
have, yes, my Lord. Para 9, it begins, my Lord, but I'm on page 10, which the paragraph begins like this, my Lord. It is further submitted.
Yes.
That in view of large number of arrear rakes, the opposite party has considered extending the facility of change of mode for delivery of coal for rail to road mode to all non-regulated sector linkage FSA, that's us, my Lord, notified with a number so-and-so and notice dated so-and-so. The petitioner was having this option to avail the mode change dispensation as per applicable guidelines for converting their mode of supply from rail to road. However, petitioner did not take appropriate action. This is not accurate because in my rejoinder, I put 2 letters. The minute they came out with this 25th February, I'd written 2 letters to them that I'm willing to take it, but there was no response at all. So even today, they stand by their affidavit. If that is so, my Lord, I have in my rejoinder, my Lord, worked out an interim solution at page 29 of my rejoinder. If your Lordship so pleases, my Lord. Page 29, I've worked out interim, my Lord. It's a para 38 of my rejoinder at page 29. My daily coal requirement, my Lord, is 62,000 tons plus so-and-so, which translates to 12.6 rakes. Against the rake entitlement of 12.6 rakes per day, petitioner is willing to take 7 rakes a day and increase the coal intake through road dispensation to 25,000 metric tons, subject to following.
Yeah. So this therefore, I think what he's saying is right. At the meeting on 6th, there will be the railways and all of them. So you can find out if this is feasible at all. This reducing to 7.1 rakes. Do they have that many rakes to give you?
Lord, otherwise,
you don't know. So you better work it out there. Mr. Mehta, it's correct that you work it out there much easier.
My Lord, I bow down to what would your Lordship just put it in the order that they will consider this, my Lord.
My Lord, all of this is there. I'm sure you will present this and they will also have their figures.
I will, my Lord. Only
Yes.
there is a little nudge from your Lordship.
That's why the hearing, right? That's why.
No, I understand, my Lord. A little nudge from your Lordship would go a long way.
No, but all of this is there to be presented. We don't want to say anything at this stage. Yes.
Yes, sir. That's it.
Mr. P.K. Pari, Learned Assistant Solicitor General of India, informs the court on instructions.
They will appear in virtual mode or anything. If
it will have to be one company after the other. It can't be together.
So one after another. Yes.
All right. In virtual mode, right? Is it in virtual mode, Mr. Pari? Who will get in touch? Who will give the link? All of that? Somebody will have to coordinate.
They have named to NX to provide the link. Accordingly, they will be joined and they will be in virtual mode.
All right. In virtual mode.
Provided they will give this all the details prior to that, then it is easier for us to give all.
The counsel for the parties are requested to coordinate with each other to ensure that the hearing takes place without a hitch. All right.
Lord, we'll provide the details, my Lord, today itself to Mr. Padi, my Lord. We'll do that.
All right. All
Then
right.
Would your Lordship consider having it, my Lord, on Monday?
I don't know if that decision will be that quick because 6th is Friday, right?
Yes. Let's
I
make
understand.
We may have to wait till Wednesday, Mr. Mehta. Let's wait till Wednesday.
1 week time may be given, my Lord. Otherwise, they will take a decision. Or different parties are there.
All right, then 16th.
Let it.
Can we call it on 16th?
Yes, no, it'll go. My lord, may I request your lordship that suggested Wednesday? May I request for Wednesday, my lord? Please consider Wednesday, my lord.
But I don't know whether they'll be ready with their decision.
Lord,
Too early, not
we take our chances, my lord. Let's. Lord, if that measure of date is there, perhaps something will not come out of it. Please keep it for Wednesday at least, my lord. We'll see on Wednesday, my lord.
All right.
Yes, my lord. It is because panic, then it will be difficult on the officials because the Ministry of Coal will take a major role in this regard. So,
then you say although MCL has filed a preliminary counter affidavit to which a rejoinder has been filed by Vedanta Limited, the court at this stage does not wish to make any observation since all of the submissions are to be made before the panel as directed by the court.
But insofar as the other two writ applications by the downstream, my Lord, Utkal Chamber of Commerce and I think my Lord Senior Mr. Mishra is appearing for the MSME.
All are requested to provide all the details. We can provide them. They will give.
We can also participate for the purpose of participation through a single representative. It won't be a rush there. Definitely.
You can watch the proceedings, I suppose.
Look, provided, my lord, they give us the link and everything so that at least we know what will.
I think requesting all of my friends, they will give all the details. They can inform the concerned ministry. You will take care of. No issue.
All right. The petitioners in the other two writ petitions shall be permitted to observe the proceedings by providing being provided the link.
Obliged.
Wednesday, my lord.
We need to keep this NALCO pending. I don't think it needs to be kept pending. Because the solution has been worked out. If you have any difficulty, you come back.
My friend would place the coal statistics before your lordship, what has been the supply position. Let her place it, my lord. Thereafter, I'll just apprise your lordship of two aspects. Your lordship, it will not take much time, 2-3
Let's do it off right away. Because why keep it pending?
No, I have filed an affidavit also.
Okay.
There is an affidavit, your lordships. Your lordships will look at annexure 5 of that affidavit, page 29.
Yes.
Your lordships will kindly keep in mind the earlier order your lordships had passed after that MOM.
No, my only thing is since there's an agreement reached between the parties, why adjudicate all this?
Your lordship, the agreement with your lordship's order was, your lordship look at that annexure, 5,000 to 6,000 to the MGR mode, 5,000 to 6,000 to the road transport mode, and then 1,000 to 2,000 to the wharf wall mode. Your lordships, that road mode is not being complied with. That's the problem. Why your lordships will remember that the FSA and the bridge link coal is actually the guaranteed coal supply. E-auction, your lordships, whatever we might have booked, which was a sparse supply, which was supposed to be made. In fact, that also was made because of your lordship's indulgence. Only because of that, but that is also
what I can say is if any part of the agreement has not yet been worked out,
lordships,
you go back to the same mechanism.
It's not been worked out, your lordships.
So you go back to the same mechanism. You see, the point is we've put in place a mechanism. It's easier now to activate that. See, ultimately, everybody's got to cooperate. So instead of judicial orders and then non-compliance with those judicial orders, it's better that we have, since there's an agreement reached, that mechanism can sort out.
The only thing is, your lordships, in pursuance your lordship's order, we've deposited the money.
Yes.
They've also told us, but they are not issuing the DO. That's the only problem. If they do that, then we will have no shortfall, your lordships. Then I think we'll be in at least a survival position. Because the auction...
My lord, may I pray? One suggestion, my lord.
Yes.
Whatever MGR situation is, all the secretaries and the MCL MD and the NALCO MD has set and they are preparing minutes.
Correct.
According to that system, let's see these FSA provisions.
Correct.
They may acted upon for some days. Let them have a patience. If anything is there, they may invoke my lord. It is better.
We are also saying the same thing. That has not been acted upon.
Yes.
We are also saying the same thing. Because this has not been acted upon, that is why this affidavit. It was from 5,000 to 6,000. So it's...
you served these affidavits, right?
Lordships, lordships. In fact, yesterday also it was 2,490, not 5,000. So that continuous shortfall is building up.
So MCL is answerable, right?
Lordships.
So what
Moment
is your
your lordship,
answer?
if your lordship just permits me 2 minutes, Lords, there's a consistent shortage of 4,000 as per your lordship's order. That part of the high power committee's meeting, which has been crystallized in your lordship's order, 11 to 14,000. The average what we are getting is, the NALCO is getting is around 10,000 and odd, close to 11,000 sometimes. So therefore, there's a consistent shortfall. Now this, my lords, this e-auction coal, which rightly my learned friend has said, which was already, my lords, that they gave 3 racks on 26, 27, 28 and 29. So therefore, there was that surplus. So on the last occasion, my lord, there was a mention made, and then it had touched 20,000 because of the backlog coal which had come, my lords. So that is not the real position. Position on the ground is something else, my lords. So therefore, I would only pray your lordship may, because 18,000 is what we need. And e-auction is not the, my lords, the guaranteed 4,000 we had to make good by way of e-auction, which is not really, my lords, there's no guarantee for that. And that stock is running out. Therefore, my lords, 18,000 we need on a consistent basis, my lords, to survive.
If they comply with that portion of the High Court's order and the MOM order of making proper supply through road, so that compliance will happen.
What they're doing is they're choking us off at the trigger level. Trigger level was never agreed upon in the high power committee's meeting. Now, after your lordship, my lords, the interim order was not continued. They are now, my lords, choking us off at the trigger level. 60% is not the agreement.
Let them answer. Let them answer.
100%.
Let them answer.
My affidavit pays 2 minutes.
You've seen his affidavit?
I have filed additional affidavit in pursuance to the order dated 2522. Your lordship see that, Millers, I have given a table, Millers.
So he says he's supplying 19,452 per day.
Sir, my lord, that is a difficulty, Millers. It is a targeted quantity per monthly quota is 3,000 something under FSA, Millers. I have given in mixture of that monthly FSA and as well as e-auction amounts, Millers. So required quantity of as per the MOM, I have supplied the Miller's coals more than that Miller's MOM Miller. Mixture of e-auction as well as Miller's FSA Miller on road mode. So from May Miller, I'll try to supply under the FSA Millers that is 5,000 to 6,000 only Millers in road mode. Because it is all on a sudden Miller's DO indent was issued in railway mode Millers, and DO was not issued on the FSA mode Millers. So that's why I have given on mixture of Millers FSA as well as e-auction Millers. So quantity is same Millers. Your lordship see road quantity Millers I have given fast table Millers. Road quantity is 5,000 and to 6,000 Millers. I have given Millers your lordship on 27/4/2000 I have given 6,624. Thereafter on 28 Millers 7,443 Millers. On 29 Millers 9,231. On 30th 9,702. And first May Millers 8,304. And second May Millers 6,000.
So if you go by these figures, even on 2nd May, you were getting 15,000. 3rd May, you're getting 14,243. So somewhere the figures are not matching.
No, Lordships, let me explain that. I'll explain that, your Lordships. None of these are contrary to each other. I'll explain what the MOM was actually confined to take a decision on the FSA and the Brinch link. In the normal times also, your Lordships, we had 3 modes of procurement. One is our FSA, one is a bridge link, and one is we go for e-auction. Because to the FSA and bridge, we maximum might have a guarantee of some 14,000. But
so this is combining the e-auction.
Yes. And that e-auction will progressively come down because that's...
But he says this will go up.
He says why it will go up because he's admitted that through that road mode, as against my FSA, he was not being provided. Correct. And now he will provide. So therefore there's no contradiction really.
This is camouflaging this is camouflaging the figures.
It's okay. I don't see it as adversarial at all.
No, this is cannot be adversarial. It is.
Yeah. Let this be pending. If they are saying that they were going to give us
monthly quota is 3,940.
No, but I think let's not go by the
under the
figure
FSA
level
millets.
we agreed.
On 68 millets, that is the millets in Manur submit the millets. There is a millets. What is that FSA, which is 60% of contracted quantity?
Wednesday at 2 p.m. This NALCO matter, you say affidavits have been filed by the petitioner, NALCO, as well as MCL, as regards the supplies being made pursuant to the minutes of the meeting, which was recorded in the previous order of this court. Stop. List along with the same at 2 p.m. on Wednesday.
Well,
all right.
All right. Only because of the pendency of the writ petition, my lords. And let me tell your lordship, the day your lordship first passed the order of 4 rakes, my lords, the decision had been already taken at the highest level in the NALCO to shut down 240 pots the next day.
Oh.
So your lordships, my lords, it was a stitch in time and it could not have been on a better time.
Because it melts.
That breathed life into that. And from that date, we are just
no
struggling.
one want to close the NALCO millets. No, in Orissa particularly, no one wants.
All right.
My learned friend is being kept at bay because of the pendency of your lordship.
Your lordships, we have also filed an additional affidavit. I represent Hindalco, your lordships.
All right.
10930.
Additional affidavit has been filed on behalf of the petitioner. All right.
Obliged.
Obliged. Oh, okay.
Sorry, my lord, I have been disrupted. So, are you fixing to some other date, man?
11th, sir, at 2 p.m.
Weekly list, old matter, item number 1.
Before your lordship takes it up, item number 3. I am engaged on amicus. My learned friend submits that his instruction is his date.
Yes, but that appellant is dead.
Oh, the appellant is dead. Oh,
yes.
Item 3, the court is informed that the appellant has expired. The appeal is disposed of as having abated. All right. We were hoping to hear you.
Sorry, my lords, I also, just now he told me.
Right.
So I said, why to wait?
Maybe some other matter. All right.
I didn't have the opportunity.
No, but you will get, I suppose.
My lord, item 1, my senior SD Das is appearing in this case.
Yes.
He is on accommodation, maybe taken up next week, any day, my lord.
Item
1, weekly list, item 1, criminal appeal 132 of 2000.
Sir, all these are 20-year-old appeals, sir.
Yes,
Actually, the Supreme Court is now...
Written note of submission has been submitted. Only, my lord may fix a date, he will argue the matter. He is on accommodation. As he has prepared the written note of submission. So,
what, sir? This is towards the end. It will only be next Thursday then, 12th.
Obliged.
All right. Stay on board. Yeah, stay on board.
Old matter, item number 2.
Yes, last Thursday. Next Thursday, I may be absent last Thursday. I can argue
Next
today.
Thursday you're
I'm
absent.
ready.
Huh?
I am ready to argue this matter.
I know. You're not there on 12th.
Yes.
Oh. I don't know about 19th. You take a chance. Okay, 19th? 19th. All right. 19th.
Last matter, 19th. Item number 2.
My lord, item number 2 and 4. One of my the briefing counsel, my lord, he passed away. Item number 4, my lord, written note was already there, prepared and it was filed, my lord. So may I pray, my lord, both the matters may be called after vacation so that I can collect the brief and I will.
Why vacation, sir?
Vacation
Argue it now. So these are all 20-year-old matters, sir.
Yes, I understand.
Next week. We'll take it next week, sir.
I understand. 1 week after, my lord, at least.
That's it, 1 week
I
later.
have a problem, my lord. My associate passed away, my lord, during last year.
That's all right, sir. For you, it won't take time to get ready. You're a seasoned lawyer. We'll take it up. Yeah, we'll take it up on 12th.
After vacation.
The advantage of us being in the bar is we know how long a senior takes to get ready.
After vacation. After vacation.
No. 12th.
On 19th.
19th. See, he's helped you. 19th.
But both may not be on the same day, my lord. 12.
It's all right, sir. It won't take so long.
No, my lord. 2 on
We're
19.
watching these things. If it takes, we'll accommodate you.
But
Not to worry.
4 on some other day, man. 4 on some other day, not in one day. 2 on 19th, 4 on some other day.
So let it be there. Let it be there. We'll on that day we can accommodate. All right, let it be there. 19.
Weekly list item number 5.
May it please, your lordship. I'm appearing on behalf of Mr. Debashish Panda, your lordship.
Yes.
Your lordship, Mr. Panda is on his legs at the moment and not prepared for the brief, your lordship. He prays for after vacation.
Madam, this is the whole problem. We can have it next week. Let it be on board. It will be next week, ma'am. All right.
Oblige, your lordship.
Weekly list item number 6.
Kindly possible, lordship, my senior just coming.
You're not audible at all, sir.
Lordship, my senior just coming, lordship.
All right. All right.
Awesome. Weekly list item number 7.
Keep only 10 matters. Nobody returns up.
Item number 7.
What's the position in this 7, sir? Mr. Katkia? Is the appellant available? I think you'll have to find out. It was enlarged on bail, I think. 11/12/2006, he was enlarged on bail. Yes, Mr.
My lord, in a very difficult situation, I am extremely sorry to pray for your adjournment, my lord. But as upon my lord, in item 6, but as my lord, the problem with my associate, who was preparing the case, and he yesterday night, mid of the night, he had been hospitalized, and I had taken him to the hospital, and I was there in the hospital till.
All right.
So, lordship,
Next week.
Next week, my lord, your lordship, we can put it
19th.
19th, but
19th. All right.
Deeply obliged.
All right. 7, I think we'll have to find out in item 7 whereabouts of the appellant.
Yes, Mr. I'll ascertain.
The present whereabouts of the appellant be ascertained through the IIC of the concerned police station. List on 19.
Item 5 also next week I am not there. Can it be on 19th?
All right, 5 also 19th. I don't know. Next week we'll rather not list anything. Next Thursday maybe we just go back to.
Item number 8.
8, same story. Same thing, sir. 8 also.
My lord.
The present whereabouts, the petition be ascertained through the concerned IIC.
19. Item number 9.
list item 9.
9 also, the appellant is working as a security guard in Kyonja.
Even now?
He's on bail.
No, but even now is he working? You have
Yes. This I have received in the month of April 2021.
All right. Mr. Mudli informs the court that the appellant is gainfully employed in Kyonjar.
For last occasion also, counsel for the appellant was present, sought for an adjournment.
Today none is present on his behalf. Notice without process fee through the SHO of the concerned police station be issued to the appellant to remain present on the next date. Meanwhile, the registry will furnish a complete set of the paper book to the secretary, Orissa High Court Legal Services Committee, who in turn will hand it over to the counsel to be assigned for the appellant, who has not less than 10 years of experience. Panel counsel. The panel counsel will get in touch with the appellant for instructions. List on 7 July.
Item number 10.
That person is available in his village. Is on bail.
All right. Mr. Katke informs that the
I have the written instructions.
Appellant is available in his village. None appears on his behalf. In the same order, same date, 7 July. That's it. Okay.